Good morning. Welcome to the Michigan Court of Appeals on behalf of myself, Judge Bazzi, and Judge Levency. I think I said that right.
You did.
Good. This is panel one for the August 2026 case call session. We've read your briefs and other submissions and are well acquainted with each of the cases. You do not need to rehash the facts or the applicable law. Oral argument is an opportunity to highlight something beyond what is in your brief or to clarify any point that may not have been as clear as you intended. By court rule, each party is allowed a total of 30 minutes for argument if opposed, or 15 minutes if only one side is endorsed. This morning, I believe our 10 o'clock session, all 6 cases are endorsed on both sides, so we'll try to keep things moving as best we can. If you plan to divide your argument time with another endorsed attorney, please advise us of that at the outset. If your clients are present, please inform us so we may also welcome them to the court. Because arguments are recorded and published publicly on YouTube, we caution counsel not to mention the name or location of any minors or other vulnerable people. We will now, I believe Ms. Stone is across the hall in the other courtroom. So we will begin with item number 2, docket number 375-287, Smith v. Amarisi. And please correct me if when I inevitably butcher names.
Good morning, may I please escort John Knockislow on behalf of plaintiff appellant. I think this is a pretty straightforward application of Yang. I'm not going to waste too much of the court's time on it. If you have questions, I'm happy to answer them. The only points I would make is I think you could decide this on one argument, on both arguments, on either. It doesn't really matter. The most straightforward way to do it probably is just to say, hey, the policy or the payment hadn't become overdue yet, therefore the cancellation is invalid. If you want to then proceed and do an analysis of also whether or not the language of their specific cancellation stuff was effective, that would be great. But I think you can decide solely on he hadn't missed a payment yet. You can't cancel a policy when there's no missed payment.
I think you articulated that very well in your brief. If anyone has questions.
No.
All right, I'll save that whatever time you need
Thank
for
you very
rebuttal.
much. And I believe we're limited to 15 minutes of oral argument if you need it based on the motion.
Thank you. Maureen DeMarco on behalf of the defendant appellee. I understand the arguments that plaintiff is making in this case. However, this cancellation was in compliance with the cure policy, relevant statutory provisions, and prevailing Michigan case law. So plaintiff is relying heavily on the Supreme Court opinion in Yang versus Everest to argue that this cancellation is ineffective. However, in Yang versus Everest, the notice of cancellation was sent to the insured's weeks before the due date. It was conditional upon their paying on time and that the policy would be canceled on the day that the premium was due if they failed to pay it. Here, Cure sent a notice of the due date to its insureds on April 5th of 2022 saying, reminder, your premium's due on April 24th of 2022. Make sure you get that in to avoid a late fee. On April 24th of 2022, after receiving no premium payment, they sent out
on April 24th, it's still the remainder of the day, so it wasn't over yet. Technically, could still have made the payment, right?
Those notice of cancellations go out at the end of the day. So in theory, if in the hypothetical situation, which did not happen here, no premium payment was ever received, that a premium payment was sent late in the evening on April 24th of 2022, the insured would not have received that notice until it received it in the mail, well after the premium payment was missed. That would have, so what they're essentially saying is he's entitled to coverage that he didn't pay for because this notice of cancellation was sent out a few hours before, was put in the mail a few hours before it should have been, in theory. But the insured never made a payment, right? If the insured would have attempted to make a payment late in the evening on April 24th of 2022, we wouldn't be here today. There would be no policy cancellation. But what happened is the insured spent 2 months without making a payment, was involved in an accident, and then attempted to reinstate coverage thereafter. But at the end of the day, the plaintiff did not pay for coverage and cannot receive coverage. The policy cancellation was sent out in compliance with Yang. And in a very similar case that was before this court in an unpublished opinion, Jackson versus USA Underwriters, that was decided in September of 2024, the facts virtually mirror those here. The notice was sent out just after the premium payment was not received. There was an option that the insured could cure the non-payment by submitting a payment before the cancellation effective date. The court said that that opportunity for the insured to cure the non-payment did not render the notice conditional, and therefore it was in compliance with Yang.
Jackson, said unlike in Yang, the cancellation notice was after the plaintiff failed to make the payment, whereas here there still was 2 hours, maybe, theoretically the rest of the day, right? I feel like it would be closer to one than the other.
Well, the cancellation notice in Yang was sent out weeks before the due date was due. So that insured received that notice weeks before the actual due date of the premium payment. It was conditional upon them making the premium payment. Here, Cure didn't receive a premium payment. They sent out a cancellation notice. The premium payment was not made on time.
All right.
I understand the record and your argument. Thank you.
Thank you.
Just one very brief point. The whole point that Yang was getting into is the reason we have these requirements is for consumer protection. It's entirely anti-consumer to go to your insured and say, okay, you got to pay. Now you still have 7 hours, 5 hours, 2 hours left to make this payment. We're going to go ahead and cancel it anyway. Or you make a payment and then 2 days later you receive a thing in the mail saying, no, your policy's canceled, but you made the payment. So I don't see how they complied with the requirements of Yang, and I think the trial court erred in dismissing this case.
Thank you both. Matter has now been submitted. We will now call item number 3, case number 371420, estate of Zachary Atiennes v. Nogueras. Please, again, correct me if I butcher the pronunciation.
Good morning, may it please the court. My name is Tim Deemer. I'm here on behalf of the defendants appellates, Challenger Motor Freight and Jose Nogueras. I believe that's how it's pronounced, Nogueras, and I refer to the plaintiffs Atiennes. I believe that's how it's said. Also with me, counsel table is Sam McLeod, attorney for my office, Brian Delgado, trial counsel for Challenger, and Mr. Nogueras at trial. Also in the courtroom, we have Jeff Topping from Challenger Motor Freight is here as well. This appellate argument is going to be a tough one for multiple reasons. The most obvious of which is it arises out of such a sad and tragic set of circumstances. It's heartbreaking to read the transcripts. And I've said this in the brief, I want to say it again today. Nothing I say about how this trial unfolded is intended to minimize their loss, their grief, anything like that. It is undeniable. That's not going to be questioned whatsoever by anybody on the defense side. It's also going to be a challenge because we have a half hour of time and there are so many, it's a huge jury verdict, $85 million, full-blown trial, a number of issues that are not controlled directly by controlling case law, which also makes it a little bit difficult. So I plan to focus on issues 1, pre-impact fright and shock, 2, conscious pain and suffering, and I hope to get to the reduction of present cash value issue, rest on my briefs on issues 3 and 5, unless the panel has questions. Of course, I'm here to answer them. And some of these issues kind of interact, so I think we'll touch each of them. Without any further introductory comment, I want to jump right to issue number 1. The trial court's decision to allow plaintiffs to pursue pre-impact fright and shock damages under the Wrongful Death Act. It was allowed to proceed and it resulted in a $24 million award, a substantial sum of money, to put it mildly. Leading up to trial, which occurred in April of 2023, there had been a dispute on how Michigan is supposed to interpret the Wrongful Death Act. 4 months before this case went to trial, a panel of this Court of Appeals issued the decision in Daher versus Prime Healthcare. We know that's been reversed. And then one other companion case decided by the same panel at the same time involving similar issues. This court's opinion in Daher, I believe the case was called Nugent or Vasquez, issued a decision that interpreted the statute in a revolutionary fashion, in a way it had never been interpreted in Michigan law, aside from a couple of Court of Appeals opinions. The Wrongful Death Act, going back to 1939, had always been interpreted as providing the exclusive list of damages that could be claimed in a death claim. If it's not within the four corners of the statute, it can't be sought under the statute. That's how the Supreme Court interpreted that issue in 1939. Baker versus Slack is another prominent case. The Michigan Supreme Court interpreted the exact same way, saying it was exhaustive list of damages. It's not a non-exhaustive list of damages. That's what Baker versus Slack said. Court of Appeals issued a contrary decision, and we now know that the Michigan Supreme Court reinstated Baker versus Slack and reinstated how we interpret the Wrongful Death Act. This issue came to a head and we're going up for trial in the spring of 2023. The defense sought to exclude pre-impact fright and shock damages because no Michigan appellate authority had ever recognized a pre-impact fright and shock claim. Plaintiffs opposed this request. They went all in on the Daher Court of Appeals interpretation of the Wrongful Death Act, that it is an open-ended list of damages. The Death Act, subsection 6, provides 5 specific examples, but under the circumstances, additional damage could be claimed based on the circumstances of a particular case. This argument was made time and time again in the transcripts. One particular quote that strikes me is first day of trial, April 11, page 14, plaintiff's counsel argued the Wrongful Death Act, all these cases they've cited, they come from a time when the wrongful death statute read differently. The Wrongful Death Act has been amended, Your Honor, and the amendment to the Wrongful Death Act says the elements of damage include, but not limited to, and they list a number of things such as pain and suffering, loss of society, and companionship. That was a clear articulation of a view of the statute that has since been rejected by the Supreme Court. In my personal view, even before the Daher opinion came out, the Supreme Court Daher opinion, where the statute specifically links pain and suffering with the period after injury when the decedent was conscious. Even under an expansive view of the Wrongful Death Act, pre-impact fright and shock is the opposite of what the statute provides. So I think under the negative interpretive canon of statutory construction, that even with the wrong understanding of the Wrongful Death Act, pre-impact fright and shock would still not be allowed because it's the opposite of what the statute says. In any event, this was plaintiff's view in the trial court, response to summary disposition, directed verdict, post-trial motion. And now we know, after the post-trial motions were decided in, I believe, March of 2024, just a few months later, the Michigan Supreme Court issued its decision in Daher. It was a 7-0 opinion. There were no dissents, of course. There were no concurrences saying we think this is unfair, the legislature should fix this. It was a slam dunk and ironclad opinion as we have. It controls the outcome here. There's no doubt in my mind. And plaintiff's response minimizes the impact of the Daher decision. I will acknowledge Daher did not decide pre-impact fright and shock, but it absolutely decided how we interpret the Wrongful Death Act. Is subsection 6 illustrative? Is it including but not limited to, as plaintiff argued? Or is it the exclusive list of damages that we have always maintained? And Daher agreed with the defense view. If one were to read plaintiff's brief on appeal, you'd come to the conclusion that the Daher opinion was a 2-sentence peremptory order that simply said a minor plaintiff can't recover wage loss damages, we reverse and remand. That is not an appropriate interpretation of Daher. It is an extensive analysis. It goes through how Michigan law treated death claims under the common law, under the old survival statute, under the original Wrongful Death Act, and it goes through the history and came to very clear conclusions that control here. Go with page 268. When the court was examining the Wrongful Death Act in its current structure beginning in 1939, quote, the legislature unequivocally repealed the statutory grounds for an estate to recover anything that was not specifically included in the damages provision of the post-1939 WDA. Page 277, and the court specifically addressed how the Court of Appeals reached its decision in Daher, which was the same argument we had here by plaintiffs. Quote, that brings us to the addition of the word including, which the Court of Appeals majority held means that the types of damages listed in the statute are non-exhaustive, end quote. Again, that's the logic that prevailed in our case. At page 278, the Supreme Court rejected the logic. Quote, we are not persuaded that by inserting the word including into the statute as part of the 1971 amendments, the legislature intended to convert what had long been an exhaustive list into an open-ended list of damages types left entirely to the discretion of the jury, end quote. Conclusion repeated at page 279, quote, as discussed above, the 1939 amendments clearly limited damages for survival act claims to those damages expressly included WDA, despite the addition of including, that structure remained in place with the 1971 amendments, end quote. I don't know how we can read that opinion and come to the conclusion that pre-impact fright and shock is allowed. Under Daher, that claim should not have been pursued. That rule of law controls in this case. On appeal now, plaintiffs walk back from that initial argument because it was rejected, which I understand why they would do that. They repeat one argument they made in the trial court and then raise one new argument. The new argument we addressed in our reply brief, it's unpreserved, it was never raised before, that the word injury could be a non-physical impact claim. That's, we addressed in our reply brief. I won't repeat those arguments here today. Plaintiff has also relied on two jury instructions, 4502 and 5002, and a Court of Appeals opinion, Taylor versus Michigan Power, to claim that fright and shock for pre-impact injuries are compensable. Those jury instructions don't support that argument. If you take a close look at them, 5002 is the general elements of damages instruction for pain and suffering. It lists a number of different types of pain and suffering damages, including fright and shock and four others. That instruction is used in all types of cases: wrongful death, personal injury, medical malpractice, trucking, it could be anything. Because of that, the instructions says you only insert applicable elements when it applies to your particular claim. So then we look at 4502, which is specific to the Wrongful Death Act. That is the Wrongful Death Act damages jury instruction. The note on use for 4502 does say elements from 5002 may be inserted. It does not say that fright and shock for pre-impact is compensable. It doesn't say that anywhere. And actually 4502 says the opposite. In terms of pain and suffering damages, this is what 4502 says. It allows, under paragraph 2, reasonable compensation for the pain and suffering undergone by name of decedent while he or she was conscious during the time between his or her injury and his or her death. It doesn't support any argument that fright and shock can exist before the injury and death. And then Taylor. Yeah.
Counsel, I guess I think you've gotten into a little bit of restating some of your argument in your brief, and I know you have a lot to bite off, and I know I have some questions. So I think I don't have any questions on this first issue at this point. If you want to move on.
Oh, I really appreciate that, the guidance. I will move on to the remedy that I think is appropriate because of this error, and then move on to the other issues. A new trial is the only appropriate relief in this case, even if the only error we had established was the pre-impact fright and shock error. If that was it, a reversal and remand for new trial on all issues would be appropriate. Daher arose out of a summary disposition ruling, so it doesn't tell us what the remedy is when there's a Daher error. It wasn't a full-blown jury trial. But there are multiple reasons why a new trial should be ordered. The standard is whether a failure to reverse would be inconsistent with substantial justice. That's from the case law, the court rule, and that standard is met here, exceedingly met here, by miles, not just an inch, but by miles. First, it's important to note, challenger availed itself of every possible procedural remedy to prevent this error from happening. Filed a summary disposition motion before trial, filed a directed verdict motion in trial, a post-trial motion. We even filed an emergency locatory appeal before trial, asking this court, please intervene, don't let this damages claim go forward. It's invalid under the Wrongful Death Act. A panel denied our appeal, not on the merits, but because of failure to persuade the need for immediate appellate review. It said, get your final judgment, then file your appeal. So where you have a record where one party, the appellant, did everything in its power to prevent this error from happening, and you have another side that did everything in its power to insist and interject this error in the trial, I think that leads to only one conclusion. The benefit should favor the party that tried to prevent this.
It wasn't error at the time, right?
I disagree.
I mean, under Daher, the prevailing opinion at the time, it was not. Okay.
I disagree. Okay, I touched on for two reasons. I touched on this a little bit earlier that even under the Court of Appeals interpretation of Daher, that it's including not limited to, pre-impact fright and shock is directly contrary to post.
The point is that the obviousness of the error, or if you want to call it that, I mean, the Supreme Court's decision in Daher changed the law as it would apply to this case, right? If Daher Supreme Court had been decided 3 years earlier, would you agree the verdict form might have been different?
Well, I agree, probably.
Okay.
But the problem is we had a Supreme Court decision called Baker versus Slack that was binding. And the Court of Appeals, this goes back to the Denny case, which I believe in 2016. The Denny case took a different view of the Wrongful Death Act, but never cited Baker versus Slack. Nobody cited Baker versus Slack in Denny. And I think that's how that original Denny opinion came out. Nobody cited the controlling Supreme Court decision. So Baker versus Slack controlled this case, even when the Daher Court of Appeals opinion was in place. And then the other response again is, even under an expansive view of the statute, pre-impact fright shock is the exact opposite of what the language provides. So I think even if you take a broad view of how we interpret the statute, this was the opposite. But I do agree, once the Supreme Court came out, that was a much different landscape we're dealing with now.
If we separately delineated the damages for mental anguish and conscious pain and suffering between injury and death, why would this infect that?
It was $24 million. It's hard to separate out a large damage award like that. And this error permeated the trial. Pre-impact fright and shock is why Judge Hathaway allowed plaintiff to question every single state trooper, every single law enforcement officer, and Lawrence Chalkley about construction barrels that occurred miles away from this accident, signage, speed limit, ask questions. How could somebody miss that this traffic was slowing down? How could somebody possibly miss these lane closures? Because pre-impact and fright shock, all of that testimony came in. And if you look at the very first day of trial, there were 3 witnesses. Trooper Kelly, I believe, Sergeant Lucidi, and Lawrence Chalkley, who was another motorist in the area. Plaintiff's counsel called those 3 witnesses. The only questions they asked of those 3 witnesses were pre-impact fright shock. Nothing else. That was the focus. And this is something Judge Hathaway actually acknowledged at trial. I had to let all these liability facts in because pre-impact fright and shock. So it wasn't as if there was this one little sliver of trial that the jury got over 24 millions and there's 90% of the trial here on other issues. It permeated every single thing that happened in this trial. And there are 2 cases I would like to highlight that support why a new trial is the remedy, not just J&O being the $24 million. The first is Fellows versus Superior Products. We cited that case many times. Just coincidentally, it was a decision by our judge's father, Richard Hathaway, when he was on the Wayne County Circuit Court. Wrongful death case, went to jury verdict. The jury awarded $500,000 in exemplary damages of a total, I believe, about $2.3 million award. Judge Hathaway concluded after trial, exemplary damages are not allowed under the Wrongful Death Act. I'm going to JNOV the $500,000, leave the rest. And this court said, that's not good enough. You did not go far enough to excise just those damages, leave the rest in place. And the reason was that, part of the reason was so much evidence was introduced to the trial on the question of exemplary damages. The attorney for the plaintiff focused on exemplary damages in closing and opening statements and closing arguments. You can't just remove the damages and then ignore all the evidence that came in on those damages. And if we think of just, again, I talk about how tragic and horrific this case is. One quote from plaintiff's counsel during opening really highlights this. When you think about what, I'll just read his quote. This is from his opening statement. He, being Jude Athese, saw impending disaster. His beloved son beside him, who would give his life for in an instant, circumstantially had to be warned. Both of them suffered huge pre-impact terror in the shortness of the time, which indeed it was, did not diminish the degree one iota. The image of the father and son seeing the truck barreling down on them, warning each other, how can a jury hear that and then set that aside and decide the rest of the case fairly. That's such powerful argument. And there was testimony and testimony and testimony on that issue time and time again. So I think Fellows is reason number one why a new trial would be appropriate. It's because it wasn't just the damages that were awarded, all the evidence and argument went into it. There's one other case. It's Ward versus Consolidated Rail, Supreme Court decision, 472 Mich 77, a 2005 case. That was another jury trial. In that case, there was one error. The plaintiff, it was, I believe it was a product liability lawsuit, and said that the defendant had the equipment that injured him, but destroyed it. And because it was destroyed by the defendant, I should get an adverse presumption. Jury should be told, you shall presume that the destroyed evidence was unfavorable to the defendant. And the trial court agreed. Case went up, Court of Appeals, Michigan Supreme Court. Michigan Supreme Court disagreed. Michigan Supreme Court said a presumption of an adverse presumption was too far. It should have just been a permissible inference. You may infer the destroyed evidence was detrimental as opposed to you shall. That was the only error, from infer to shall. But what the reason the court believed that was an error that warranted setting aside the trial fits this case to a T. And this is a quote from page 87 of that decision. Quote, the trial court's erroneous ruling on the adverse presumption and the numerous references by plaintiff's counsel to the ruling during trial fundamentally prejudiced defendant with respect to the FSAA claim because it significantly interfered with the jury's ability to decide the case intelligently, fairly, and partially. So when there's an error and it permeates the trial, and in Ward didn't even permeate, it said there were frequent references to it. We have more than, I don't know how you distinguish between frequent and permeate, but here we had way more than frequent references. It was brought up time and time again. Every single witness, every state trooper who testified, the defense called the state trooper, their questions were all pre-impact fright and shock. So a $24 million JNOV, it's strange as to say, is not enough in a case like this. Unless the court has questions on that issue, I intend to move on to conscious pain and suffering as my next issue. I'm not going to discuss the Dr. Mankowski issue because we briefed that one extensively. I just want to point out plaintiff's counsel takes a too narrow view of the Morinelli decision that we cited. It wasn't just based on relevancy, which is what plaintiff's counsel said in their brief on appeal. It went to the procedural unfairness of allowing an expert to testify on an issue that they were not properly disclosed for under Michigan court rules.
I actually have a question on that, though. I understand. It doesn't appear as though that any objection was made to Dr. Mankowski's qualifications to testify. There was no Daubert hearing held. Am I correct on that? Is that it doesn't look like there was any, again, objection to him actually testifying. It was more of a procedural, can you substitute him? Am I right?
That is correct.
Okay. And are you saying, and I understand your argument in the brief about, I understand the argument, I think, but I don't know that I agree with it. The original doctor's affidavit said something about he was going to testify to mechanics of how the accident happened. You know, I know you take an issue with the actual testimony as being different from that because it talks about two impacts. But are you saying the testimony was so substantively different that you couldn't effectively cross-examine, or that your own expert witness couldn't address that evidence or that testimony?
Starting with Dr. Dragovic, the defense expert. We got Dr. Mankowski's trial transcript at 9 o'clock the night before Dr. Dragovic testified. We got it from the court reporter at 9 o'clock. He starts his work day for the county at like 5 in the morning. So he's in bed by 7. So he was already asleep by the time we had a copy of that transcript. So he wouldn't have had time to review it. But then taking a step back to your original question about his opinion not being Shields. We know his opinion was not Shields. And it was false when it was stated on the record at the time that his opinion would be the same. And we know that because Dr. Mankowski was asked what information did he rely on to formulate his opinion. And he started his opinion on April 10th, and he testified on April 17th. So we had 7 days to formulate this opinion. He was asked, what did you look at from your opinion? His answer was police records, autopsy reports, and photographs. He didn't look at anything Shields had to say. He didn't look at Shields' reports, affidavit, nothing from Shields. He was asked, did you even talk to Dr. Shields before he testified? His answer was no. So how could his opinion mirror Shields if he doesn't even know what Shields' opinion was going to be? So just existentially, I don't see how that could be possibly be the same opinion if he never communicated with them to even understand what his opinion was.
I suppose, didn't you create the situation where you needed the substitute, where the substitution was needed at the last minute by not dealing with the issue of liability in advance?
Okay, I want to, I'll start with the remedy that Mr. Delgado offered was, this was announced during trial that Mankowski was switching for Shields. He said, give us an hour to depose him, so we at least know what he's going to testify to. And the judge turned that down. That would have given us his opinion. Or the court rules required a supplemental disclosure. Once Dr. Mankowski substituted for Shields, there was a requirement to supplement Dr. Mankowski's disclosure under the discovery court rules. That was not done. So it's partly on us, if you want to say that, partly on them. And if Judge Hathaway had allowed that deposition, I think that would have gone a long way to ameliorate this prejudice. Because by the time Dr. Mankowski testified, we didn't know what he was going to say until he was on the stand. We didn't know he was going to venture into biomechanics and all these other kind of areas of testimony, except right on the stand. And I don't know if procedurally it's proper to stop the argument and stop the cross-examination and have a Daubert hearing. But what we did do is we challenged it on the sufficient evidence grounds post-trial motion, which we're allowed to do. There's a case, Napier versus Jacobs. We don't have to file DV. We don't have to file a pre-trial motion. We can raise for the first time the sufficiency of the evidence of the claim that was made, which is what we did. So any shortcomings would have been cleared up by that motion, and the judge had an opportunity. She actually said on the record, she's like, I'm gonna let him testify. If I need to clean up later, I will. She said that on the record, but then didn't avail herself of that opportunity when it was presented to her. I think it should have been done. One final comment on this is another question of remedy. Plaintiff's counsel suggested the only remedy would be a new trial, not judgment notwithstanding the verdict, and quotes a case called Tennyson, which is a Supreme Court decision. I disagree with that view. Tennyson was a peremptory order, is very fact specific, and it held, quote, on determining that the trial deposition of April Tennyson was improperly admitted, the appropriate remedy was not entry of judgment for the defendant, but rather a new trial at which the plaintiff could seek to offer other evidence on the subjects covered by the trial deposition. So
This is on the issue of conscious pain and suffering.
correct.
So the remedy of, you're asking for essentially a directed verdict on the issue, the insufficiency of the evidence. Okay.
Correct, because the evidence on retrial would be the same. All of the scene witnesses testified that when they got the Atenese vehicle, there were no signs of breathing, life, activity, nothing whatsoever. Lawrence Chalkley was the first one to approach their vehicle. After the accident happened, he took off a seatbelt admirably. He's a great human being for doing this. He immediately went to the Atenese vehicle to try to render aid. By the time he got there, there were no signs of life, no signs of consciousness. And Dr. Mankowski said, even when Lawrence Chalkley was there, they were still conscious, despite all appearances to the contrary. So we have Tennyson is that limited holding, but that same Supreme Court, so this was a 2004 decision in Tennyson, 3 months later decided Craig versus Oakwood Hospital. And in Craig versus Oakwood Hospital, the Supreme Court concluded the plaintiff failed to prove causation in that medical malpractice case, and they ordered a JNOV on the claim. The Supreme Court didn't say, well, you didn't prove causation on the first time around, we're going to give a new trial to prove it on the second. They did not do that. Same exact Supreme Court. I'm going to try to just two very, very brief comments, save some time for rebuttal. I believe a new trial would be warranted, and there should be some remand instructions on how the second trial should be conducted. The first one, I think liability facts should only come in to the extent they inform whatever damages claim can be pursued. If conscious pain and suffering would be allowed on a new trial, accident facts limited to the speed of the vehicles, the force of impact immediately before and after the accident, those issues would inform conscious pain and suffering. Those should come in 100%. What happened with the Department of Administrative Transportation in 2015, Parkinson's disease, sleep apnea, mile markers miles away, has nothing to do with conscious pain and suffering. That stuff should not come in. It should be narrowly tailored to the damage issues that are remaining. I also think on remand, the reduction to present cash value error we raised should not be committed a second time. It had its exact intended effect. We don't always know how juries reach their decisions. It's sometimes if you're not in the deliberation room, how do you know how they decided this? In our case, we know exactly how they decided it because they awarded for year one of loss of society companionship, $150,000. Year 53 years of healing, more than 5 times that number. It's because they were told the judge is going to reduce your verdict after you issue it. And if you want to give the family what you want to give them, you've got to increase that by 5% going all the way up. That is
Well, didn't they increase it by 3%? If you actually multiply it out, 3%?
they went by 3%,
Okay.
not the 5%.
But is there any evidence from the verdict that they considered the whole adjust for present cash value? I mean, it seems like they just added 3%.
Well, the proof is in the verdict form. Look at the lines. It's 150, then by 3% all the way up. That defies common sense.
I understand your argument that it's not logical, but it's not because they, considered reduction to present value. They just added 3%.
Right. And okay, maybe I'm misunderstanding. It's not logical, but they clearly added 3% on the way up. And I know what plaintiff has said. That's what defense counsel told the jury to do. That's false. That is not true. Defense counsel did say $150,000. Agree. Did say 3%. I agree. But on the very next page, and this is not included in their brief, they only cite that little section of what defense counsel said. Defense counsel gave a completely different set of numbers to the jury. He said it should be for Jude Athanasi roughly $3 million and for Zachary Athanasi roughly $12 million, $50 million. That's what the number's always been. And it wasn't defense counsel saying, even though they're going to heal and overcome this loss as time goes on, you should just increase all the way to the future. That's not what was argued by defense counsel.
I don't want to use up the very last minute or two of your time, so.
Okay. Well, if you have a question, that's what I'm here for.
No, I want to make sure you leave some time for rebuttal if you want it.
Thanks, Rich.
Good morning, Mark Ronzaro on behalf of the plaintiff appellee. I'll reserve for the end of my argument the thing with respect to reduction to present cash value. Let's start with Daher. Okay. Daher obviously did not involve anything related to non-economic damages. Daher was a case in which the Supreme Court considered whether a 13-year-old child could make a claim for future lost earning capacity. Nothing in Daher addresses the precise issue that was presented in this case. And understand, Judge Ackerman, you worked in a Pion case, and you've obviously gotten in touch with the convoluted history of Michigan's wrongful death and survival acts. But that convoluted history was retraced in Daher. And what the court ruled in Daher undeniably is that any request for damages under the act has to be included in that list of damages after the word including in 2922 sub 6. It's got to be there. And it's very interesting to me that Mr. Deemer has spent a whole lot of time telling you that that's what Daher says and not telling you about the actual provision in sub 6 that does apply in this situation. No analysis today of sub 6 and what it means, but that's what Daher is pointing you to. You have to look at that. Now, understand another thing about what he says about the positions that were taken. When this case was tried, it really wasn't tried under the Court of Appeals opinion in Daher. It was tried under Jenny. The Court of Appeals decision that said the word including was just a suggestion in 2922-6 that you could have any damage, okay? So the fact is there was no reason in the trial court to anchor this a claim for pre-impact fright and shock in sub 6. There was absolutely no reason to do so, precisely because Danny said that list was not inclusive. And what Daher reversed when it issued the Supreme Court issued its decision is that no, that list is exclusive. I somehow question that logic, but that's what the Supreme Court decided. Okay, it's exclusive. That means we have to look to sub 6. There was no reason in the trial court to look to sub 6. So to suggest that we have changed the position, there was no position to take with respect to pre-impact fright and shock. And what Daher said is you got to look at this. And here is the language of sub 6 after the word including. It encompasses the pain and suffering while conscious undergone by the deceased during the period intervening between the time of injury and death. Now, the first 3 words important in that sub 6 are pain and suffering. And there is no question, none, that pain and suffering includes fright and shock. That's obviously evident. You only need to look at MCOA JI 50.02. These are the elements of pain and suffering. And sub C in 50.02 is in fact fright and shock. And indeed, you know, it's interesting. I in a footnote in the brief, but the defendant's attorney, if you look at footnote 2 of my brief, the defendant's attorney agreed when they were talking about, well, how this was going to go on the verdict form, because the defendant said, defendant's counsel noted that the model and jury instructions, quote, lump the pre-accident fright and shock and conscious pain and suffering into one category. Well, he was right. That's what 50.02 does. So the first element of the actual sub 6, pain and suffering, is undeniably correct. Pain and suffering includes fright and shock. Now, the next question becomes a mystery word in 2922 sub 6, because it has to be in pain and suffering has to be in the period intervening between the time of injury and death. And the argument that the defendant is now making is in fact, no. They didn't suffer the injury until the impact. Well, think about it. 50.02 says that fright and shock is in fact an element of pain and suffering, which means you can collect for that injury. And we have cited in our brief a number of Supreme Court cases in which the fright and shock alone is in fact an injury. And one of the more amazing things about the defendant's reading of Daher is that there is a case which directly refutes their position with respect to what Daher says. And rather amazingly, that case is Daher. Because as you know, and as Mr. Diemer has explained to you, the Daher court looked at Baker versus Slack, and they said Baker versus Slack is still the law. And what the Supreme Court ruled, and what the Supreme, I didn't have the site at the time I wrote my brief, but it's at 515 Mish 269. That's the Daher opinion, describing the damages available under sub 6 based on Baker versus Slack. And here's what they said. The newly combined WDA specifically divided the damages recoverable into 3 classes: pecuniary injury, not involved here; reasonable medical, hospital, funeral, and burial expenses, not involved here; but also the pain and suffering of the deceased before death. The pain and suffering before death. That's what Supreme Court in Baker versus Slack read sub 6. And what do we have? We have pain and suffering under 50.02 for impact shock and terror is in fact pain and suffering, and it's pain and suffering before death.
Let-
The-
Can I ask you something? If
Yeah.
we're supposed to, I guess, adopt your view, then wouldn't the pain and suffering that occurred pre-impact and the pain and suffering that occurred post-impact, wouldn't those all have just been one amount for the jury to consider? Why would it be separated?
Well, but they were separated. I mean, I can only assume that with good lawyers trying this case, they were separated precisely because of the motions for summary disposition that were filed. Look, I'm an appellate guy, okay? But every now and again, lawyers call me when they're in trial and they say, we got this, we got to put together a verdict for it. And my question to them every single time is, okay, have you got different theories? Had any been challenged legally? They want a summary disposition, directed verdict, whatever. Okay, my advice is always the same. If they're being challenged, one of them is being challenged, segregate them, separate them, because otherwise you lose the entire verdict. You've got to separate them. And in this case, there obviously were very distinct 3 different claims of damages. This is lawyering. It's not being underhanded in any way. It's the advice I would have given. I know Mr. McKean calls me. Maybe he did in this case. I don't know.
I'd like to ask the same question in a different way, similar to what I asked opposing counsel, which is if someone were to make that call to you now, post Daher, and looking at this verdict form, would you separate out the 2 categories?
I would certainly separate them out.
You would?
Yes. I
Even
would
under your
separate
argument
them out.
that pre-impact
Why
fright and
not?
shock is part of the injury. The
Yes.
second category is injury. I mean, doesn't it seem
I would
duplicative?
separate them out strategically to let the jury know that there are in fact 3 different claims of damages. There really
But under
are.
the statute, there's 2. Under Daher in the statute, it's from injury to death. I understand your argument, which is that the pre-impact fright and shock is part of the injury. But that's what category 2 is on the verdict form, isn't it?
The verdict form is to direct the jury in the formation of its verdict.
And it says injury to death, conscious pain and suffering
Yes.
from injury to death.
Well, okay.
And now
I
you're
would
saying
say-
that category 1 is also part of the injury, and that's the problem. I mean, I understand why that might have been good advice before Daher, but under Daher, under your argument that pre-impact fright and shock is part of the injury, but category 2 covers injury.
But what's the difference? What's the difference? I don't know.
Right. What's the difference? If it's all injury, then they shouldn't be separated.
Whether they were separated or not, the fact is, I will grant you this, they are both pain and suffering, and they are both pain and suffering suffered before death. And under Daher and its reading of Baker, that is recoverable under sub 6. You are correct. Okay.
Yeah.
But would I still give them the advice to separate? Absolutely, I would. Whether my advice is good. or bad. Okay, no, but the other point that Mr. Deemer raises is the remedy if this is if there was something wrong with this. Okay, and the fact is there was nothing wrong with submitting this to the jury because the Daher does not overrule in any way this request. But the suggestion that the segregated amount somehow leads to a full new trial is incorrect. Mr. Deemer tries to tell you that the inclusion of pre-impact shock somehow opened the floodgates to the evidence that would come in this case regarding the accident itself. It's very curious to me. Mr. Deemer has decided not to talk today about his argument with respect to the purported inappropriate actions by the plaintiff's counsel. It's interesting to me because that argument would have demonstrated to you that the evidence of the accident, how the accident occurred, had to come into this case. It had to come in for 2 reasons, at least. Okay, and one was, of course, pre-impact fright and shock. But what Mr. Deemer ignores in making that argument is there was a second element that even the defendant's attorney recognized, that the jury had to hear about this accident. And in fact, it was the defendants who wanted the jury to hear about the accident, and that's conscious pain and suffering. The defendants had to let the jury know that there was this gigantic truck going well in excess of 50 miles an hour, made no attempt to stop and hit the back of my client's car. The defendants needed that evidence. Why? Because they wanted to demonstrate that this accident was so intense, so violent. My clients were killed instantly. That's what they wanted. So the suggestion by Mr. Deemer that you should reverse the entirety of this case because the pre-impact shock was somehow the entree to a great deal of evidence coming in as to how this accident occurred is absolutely wrong. The fact is that without that, there still would be evidence in this case with respect to how the accident occurred. And I think it's important to understand in terms of the argument that has been made, how the accident occurred had to be part of this trial, even with the concession of liability. And the defendants wanted it that way. Why the accident occurred was not appropriate because that would have gone to negligence. And the trial court did in fact shut down the plaintiff when the plaintiff tried to elicit testimony as to why it occurred. That would have gone to negligence, but that wasn't allowed.
So what would be the appropriate remedy then?
Well, the appropriate remedy is to affirm, precisely because this case has nothing to do with
Well,
our, and in fact.
I'm going to stop you for a second and let me rephrase my question. If we decide that the pre-impact damages for shock and fright weren't appropriate, what is the appropriate remedy?
They were inappropriate, you say? The appropriate remedy is to strike that element of damage. That's correct. And the cases that Mr. Deemer relies on are completely different in the sense, because what he's talking about in these cases, I forget, the Fellows case. The Fellows case is a situation in which the plaintiff introduced the concept of exemplary damages. And as you perhaps know, when you get into the element of exemplary damages, you can get into a lot of bad acts by the defendant. And that's exactly what happened in Fellows. There was a lot of evidence impugning the conduct of the defendant precisely because the plaintiff had one theory, exemplary damages, that was in there. The Court of Appeals struck the exemplary damages and they were compelled to throw the whole case out or reverse the whole case, I should say. And that's because all of this evidence came in that wouldn't have come in otherwise. The point of this case that's very different is in light of the fact that we had the conscious pain and suffering issue always in this case, the fact is that the evidence that came in would have come in anyway. Now, let me turn to conscious pain and suffering if I can. Conscious pain and suffering in this case. First of all, I'm still trying to piece together what the defendant's position is with respect to conscious pain and suffering, because there was a throwaway part of their brief, I thought, which suggested that Dr. Mankowski, who undeniably testified with respect to conscious pain and suffering. Dr. Mankowski's testimony was quite simple. He said that based on his examination of how the accident occurred, Jude Antinese would have survived for 1 minute and Zachary for 3. That's the bottom line of Dr. Mankowski's testimony. The fact is that the defendant is now suggesting that that testimony somehow should have been excluded. The defendant is further suggesting that once that damage testimony by Dr. Mankowski is in fact removed from the case for as improperly admitted, that you should in fact grant a JNOV. I want you to know that it was about 21 years ago, I took this very issue to the Michigan Supreme Court, and I got a favorable ruling. Mr. Deemer is correct. It was based on an order by the Supreme Court in Tennyson. Okay, but it is Supreme Court precedent, and it is absolutely correct. And that is, when you are addressed, when any court, an appellate level court, is addressed with the question of whether a directed verdict or a JNOV should be issued based on insufficiency of the evidence, you review all of the evidence that was admitted at trial. It's as simple as that. You do not judge a JNOV or a directed verdict issue on the appellate level by subtracting evidence that was improperly admitted at trial. That's the fundamental point that Tennyson stands for. And that's a very important point in light of what Mr. Deemer is arguing to you. The fact is, you do not subtract testimony that the trial court admitted at trial and then declare that there was no evidence. So that issue is completely by the boards. But let's talk about Dr. Mankowski's testimony. First of all, as you know, Dr. Mankowski was a late arrival in this case with respect to his conscious pain and suffering testimony. But his late arrival to this case was directly due to the tardy concession of liability that the defendants manufactured, I think, in this particular case. Because what happened in this case is on the eve, not only on the eve of trial, right at the beginning of this trial, we finally got a concession as to all of the issues of liability in the case. It was only then, and the trial judge, I think, noted in a footnote, the trial judge concluded that the concession that was announced basically at the time of voir dire in this case led to 70% of the trial being unnecessary. All of the liability issues in the case had been dropped. 70% was dropped, but that 70% meant Dr. Shields couldn't testify. He was the person who was going to testify. And let me say this. We have pointed out in our brief that what Dr. Mankowski testified to, 3 minutes for Zachary, 1 minute for Jude, is exactly what they would have gotten out of Dr. Mankowski. Now, the problem is, for the defendants, they never deposed Dr. Shields. They never deposed Dr. Mankowski, who in fact had been identified as a witness with respect to Parkinson's. They were both witnesses. They were never deposed. But I can represent you, and we have proof of this. And if you want, I will file a motion to supplement the record, because there is in this case clear evidence that what Dr. Mankowski testified to, 3 minutes and 1 minute, is exactly the testimony that they would have gotten out of Dr. Shields. Okay, and the fact is Dr. Shields couldn't testify because the defendant's late concession. He was unavailable. The defendants even acknowledged that in their post-trial motion. So they were part of the problem here, okay? And the Dr. Mankowski's testimony was completely admissible, and I'm still confounded by the reliance on this Morinelli case. Morinelli has nothing to do with the issues you're dealing with here, because no matter how Mr. Deemer slices it, Morinelli is a case in which the defendant's expert was testifying to something, not that it was surprising, it was irrelevant. And that's what the Court of Appeals ruled. So the suggestion that Morinelli is somehow applicable here is still kind of a mystery to me.
Your opposing counsel suggested I mean, if we were to find a problem with the conscious pain and suffering kind of verdict, obviously they're suggesting insufficient evidence, JNOV, wipe it out. What is I mean, there is obviously a legal standard for considering a motion for a new trial for an excessive verdict. You know, it goes through all the different factors, one of which is, well, there's 3 main factors. What is your suggested remedy? How do you view
You're talking about the admission of Dr. Mankowski's?
No, I'm now talking the next step, which is, okay, they heard the testimony is fine. The jury's verdict is what it is. I mean, there's also a general suggestion or question about how big the verdict is, right? The defense argues, look, way too much for 1 minute or 3 million.
Yes.
Do you have any guidance or suggestions on how I'm to
Well,
think about essentially a 1 minute and let's assume you're right, 1 minute and 3 minutes.
Yes.
What do I do with that?
Well, the only thing that I have suggested in the brief with respect to that, and there has really been no argument by the defendant with respect to the excessiveness of this particular element of damage, if you think about it. Because what the defendant has argued in this case is that the entirety of the verdict, and that's incorrect. That's an incorrect approach. They really have not challenged the $8 million or $11 million with respect to conscious pain and suffering that the jury awarded. The only thing I would suggest to you, okay, is Dr. Dragovic's testimony. Dr. Dragovic was their expert with respect to conscious pain and suffering. I forget his exact words, but basically he referred to it as like unbearable torture. This is unbearable torture. And obviously we are dealing with a short period of time. I have cited in the brief a number of cases, a couple of them I think involve airlines where a plane is crashing and everybody knows the plane is crashing and they're going to die. And these cases do in fact result in substantial verdicts, even for the short period of time that the plane is diving and the people realize they're going to die. What we have in this case, and what Dr. Mankowski testified to, is that we not only have a person knowing they're going to die, but also knowing that the loved one sitting right next to them is also going to die. And yes, it's a tremendous amount of money for 1 minute or 3 minutes, but I would suggest I have listed the cases that I think are pertinent to these very short time periods and the damages available. And let me turn just briefly, if I can, if I have any more time left, to the question of reduction of the present cash value. In my estimation, there was an error committed with respect to the reduction of the present cash value, and it was the error in denying the plaintiff's motion, because the plaintiff moved pre-trial to have the court address the jury and tell the jury that there would be this reduction to present cash value. And the court said, no, you can't do that. You can't do that. But I'll let you talk about it in your closing. That's what she wrote. That was the error. If there was any error associated with it, it's that the trial court is, bound to tell the jury about the law. Well, the law is that this verdict is going to be reduced, and it's going to be reduced to, well, the future damages, of course. It's going to be reduced in a very substantial way, especially for someone like Zachary, who was very young at the time of his death. The jury should know that. Okay, but the other thing to know about their argument and why it's completely wrong, you made reference to the 3%. The jury did exactly what the defendant's attorney told them to do. He told them to start future damages at $150,000 and multiply by 3% per year. That's what the defendant's attorney told the jury to do. And guess what? It's exactly what they did. In fact, they sort of undercut the defendant's attorney because he said you could Zachary, you could award 150 to 180 and do 3%. They started at 150. They did less than the defendant's attorney suggested. So the suggestion that there is some sort of error associated with this is completely incorrect. The jury did exactly what the attorney for the defendants said. The jury did exactly what the defendant's attorney said with respect to the loss of society and companionship, which hasn't been discussed here today. But the defendant's attorney in his closing argument told the jury that you should award substantial damages for loss of society and companionship to a widow and 2 daughters, 2 sisters, You should award, if you award, he said, 20 to 30 million dollars, that's your job. That's his exact words. That's your job. 20 to 30 million dollars. And guess what? When you do a reduction to present cash value, the jury's award of loss of society and companionship, past and future, $25 million. The jury awarded the range that the defendant's attorney suggested. So they claim that there's somehow an outrageous amount of damages being awarded in this case, particularly with respect to loss of society and companionship, completely by the boards. The one other point I wanted to raise, because if I may, about Dr. Mankowski, I was a little confused about the defendant's position on whether they preserved issues regarding 702. I went back to the transcript, just so you know, and I wanted to make sure you have this, because the transcript of the morning of 4/17/23, it's a little confusing in this case, the morning and afternoon, just before Dr. Mankowski testified, the attorney for the defendant said, excuse me, the plaintiff's attorney said, we're going to call Dr. Mankowski. And the defendant's attorney, the court says, and I'm excuse me, I'm reading from page 49 of 4/17/23.
I'm sorry, 49,
morning.
you said?
Yeah, and the trial judge says, okay, we can have a quick Daubert hearing. And the defendant's attorney says, Judge, I don't need to take testimony from the doctor. Okay, I just want to make certain arguments. And the only argument he made at that point was that it was sort of what we call in the med-mal area, badalamenti argument. That is he said that Mankowski can't testify because it's contrary to fact. Okay, no raising of 702, no raising of any other issue regarding qualifications. So I want this to be understood. My assessment in my brief was only slightly incorrect. They did raise one issue, and that is there was no evidence to support his position. Mind you, there was no evidence to refute his position either, which means we don't have a badalamenti issue. But there were no questions raised regarding 702 or his qualifications. I want to make that clear. Any other questions?
Any final questions? Thank you.
Thank you.
I'm gonna try to get through as many quick points as I can. Dr. Mankowski's opinion, there's one other problem with it. It is speculative on the 702 issue. It's insufficient to establish conscious pain and suffering. His view was that both Jude and Zachary Attanisi suffered internal decapitations, had their spinal cords severed with a host of other issues, but they remained fully conscious because there's a reserve of oxygen in the brain. And no matter what happens to the physical body, that reserve of oxygen is going to restore consciousness. So he was asked, because what that means is, unless literally, this was a testimony, someone took a bullet to the head through the brain, there's always going to be consciousness before death, no matter what. And he was asked this question and confirmed it on the record. Question, if you're saying there's a reserve of oxygen in somebody's brain or head, seems like you're saying there's never a situation where someone's going to die instantly and not having awareness whatsoever. His answer, I can't think of a scenario that would happen. And his only exception would be in combat or war. So that was his opinion. I'm going to jump to Baker versus Slack, because Baker versus Slack affects both pre-impact fright shock and post-impact fright shock. Baker versus Slack was a motor vehicle on pedestrian car accident. The driver of the car testified, when I struck her, I heard her scream. And the Michigan Supreme Court said that's not sufficient to establish post-impact conscious pain and suffering. It's instantaneous conscious pain and suffering, but you only get post-impact. So that's a pretty clear indication we have a strict time duration on when those damages are allowed. And this is what the Supreme Court held. Quote, there is no testimony that decedent was conscious after being struck. Plaintiff contends that defendant's admission that he hit something and heard someone or something holler at the same time is indicative of conscious suffering by decedent after she was struck. But the outcry occurred at the instant of the collision, not during the period mentioned in the statute, intervening between the time of the inflicting of such injuries and her death. End quote. That's Baker versus Slack at page 707. So instantaneous conscious pain and suffering is not allowed. It has to be after that injury, after that impact. And then I'm going to just address reduction present cash value.
So if you could wrap it up, just, we're out of time now, so.
Okay,
Any like final point?
final on reduction present cash value. Judge asked about how do we know what the jury did with the reduction present cash value? We never know. We never can know. We're not there in the deliberation room. But what the case law says is when we can't know what happened and what didn't happen, the burden falls on the other side that caused the error. I'm going to quote a case called Lapisinxis versus Quick, 17 Mishap 733, published opinion from this court in 1969, where an error was made during trial and the party that committed the error said, well, we don't know whether it impacted the jury or not. And this is what the court held. Quote, we have no way of knowing whether the defendant's injection of this issue influenced the jury or whether the trial judge's cautionary instruction in fact removed any effect adverse to plaintiff's claim, period, end quote. And they reversed. We don't know. That's the point. It's impossible for any appellant to say, well, the jury definitively did this because we knew how they deliberated. We don't know. And the burden falls on the party that injected the error. Any other questions? I'm happy to answer.
Any final questions?
I have a procedural question. One thing we realized just recently is that some of the transcripts didn't get submitted and transferred to this court timely. Does anyone I'm newer here. Does anyone know whether there was an error or what happened? Now we're trying to figure out.
Mr. Gonzaga, we're talking about that very thing. That email took us by surprise from the clerk's office because they were filed in the trial court. And
I think the issue is each day had a morning session and afternoon session. So is that just an oversight? Is that?
I think it's funny. That's exactly what we were discussing. I've never seen it before where you have a April 10A, April 10B, as opposed to a full day. It might be because the parties were ordering the transcripts daily and getting them as quick as they possibly could.
Okay, thank you.
Thank you very much.
Well, thank you very much. It's been well briefed. We will take it under consideration. The matter has now been submitted. We're going to proceed with the docket and then we'll return to one at the end. So we'll now call item number 4, case number 375886, VHS of Michigan versus MAIPF. Absolutely.
Left my screen. Good morning, Your Honors. Malia Vislowski on behalf of the plaintiff appellant VHS of Michigan, doing business as the Detroit Medical Center. I typically just refer to them as DMC if I bring them up in my argument. This appeal, the resolution of it, really turns on whether or not the rebuttable presumption under MCL 500-3107C3 under the no fault reforms can override the statutory eligibility criteria that the legislature set for the 50,000 coverage limit, which is referred to as the Medicaid option, the 50,000 Medicaid option. And this is the second round of appeal in this case, specifically, this issue is the only thing back before this court. And what we are asking is that this court look at this issue and make the determination that 3107C3, the rebuttable presumption, does not apply in cases involving the statutory eligibility for the 50,000 selection. The $50,000 PIP coverage limit under 3107C1A is categorically different from all the other coverage tiers that are found under 3107C because it is restricted to persons that are enrolled in Medicaid, and you must meet two criteria in order to even be eligible to select that $50,000 option. The first one, as I said, is you must be enrolled in Medicaid, and if a spouse or any other resident relative, they must have Medicaid, QHC, qualified health coverage, or be covered under some other alternative no-fault policy. So there's two requirements. And as this court has recently, they looked at, in the Northland radiology case, that dealt with 3107D, which is the corollary to 3107C, dealing with the Medicare coverage. And basically, while that was dealing with Medicare, the court essentially said that because the statutory eligibility to make that selection had not been met to the letter, then it was an ineffective selection and it defaulted to unlimited coverage in that case under a Medicare selection. Here, Ms. Downer, it is undisputed that Ms. Downer was not eligible to make the $50,000 Medicaid selection in the first place. And the reason for that is the evidence establishes the defendant, USA Underwriters acknowledges in their briefing that she was not medically indigent. She actually had, at the time of this policy, at all times relevant to this accident and her injuries, she was employed and she had a commercial Blue Cross Blue Shield policy through her insurer. So she was never qualified under the statute to make that selection in the first place. When this case was before this court the first time around, shortly before we had oral arguments in this case, Downer 1, I will call it, this court issued its opinion in the Bronson Healthcare versus Esurance case. And in that case, it involved a $250,000 selection. So in that instance, it wasn't a statutory eligibility question like we have here. That was a choice that anybody can make. Under 3107C, we have different choices now from the reforms. You can select 250,000, 500,000, unlimited. But and anybody can make those. There's no statutory requirements other than there's certain items under the statute that have to be followed, but it's not a statutory eligibility issue like we have with Medicaid, because not everybody can choose this type of policy. So the Bronson case, we argued, and I submit again, I think the Court of Appeals in Downer 1 acknowledged that Bronson versus Esurance was a different situation from what we have here. However, they still said the rebuttable presumption applies. C3 applies. We're going to send this back to the trial court. USA Underwriters is going to get an opportunity to present an affidavit. And then DMC, you get an opportunity to then see if you can rebut that presumption. And that is what I submit was the error in the original Downer 1 opinion that we are addressing here. Because what the rebuttable presumption does is basically it is an opportunity for the insurance company to say, okay, there's something that happened here with the selection that was made. So we will bring forth an affidavit that basically says, well, this is the premium that was paid that corresponds with the 250,000 or the 500,000 that was selected. I'm just using that as an example. And in those instances, an affidavit would supply the information to help determine what that policy coverage, what the parties intended to do with that selection. In the Medicaid situation, A rebuttable presumption is never going to transform a policy that should have never been issued in the first place because they were not eligible into a legally valid one. Just because you can bring forth an affidavit that says, well, this is what we would have charged for the $50,000 premium, and we got a payment for that, that defies the statutory language that clearly states you must meet these criteria to be eligible. And if you don't, then there is no rebuttable presumption that should come into play to breathe life into a policy that was legally invalid in the first place.
Wasn't that largely your argument the first time and,
Well,
the prior panel didn't go your way? And so I understand your argument, but wouldn't it require us to reverse a previous panel of this court?
well, it would require the statutory language to be enforced as written and understand that this is this really is the first case dealing with the 50,000 Medicaid selection and understanding the nuance between the 3107C1A. That selection is really an eligibility requirement versus a choice anybody can make. So there is a difference, and what we believe in those limited circumstances, the way that 3107C is written, it provides for a default to unlimited benefits. And it is a corollary to 3107D, which is under Medicare. Whereas if that selection is not met, like the Northland radiology case, that was an instance where the policyholder had Medicare herself. She goes and gets a policy. She has Medicare. She provides the Medicare documentation. But it turns out she didn't notify the insurance company that she had I believe it was an adult son living with her. He did not have the requisite insurance and requirements under the law to meet that. So what this court said in Northland radiology was it reverts, to an unlimited policy. So what we're saying is it would be the same situation here if you are not statutorily eligible under 3107C1A, then it defaults to 3107D. I didn't know if something I was doing was creating the static, sorry. The point is there's no premium payment if a rebuttable presumption comes into play that would transform a statutorily prohibited policy like we have in Downer into a valid one. There's just, I guess how I would phrase this is it's the statute, not the premium, that determines the eligibility under this selection. I forgot to mention, so I would like to reserve a few minutes for rebuttal, so.
I don't think there's any, I don't think we have
Oh.
oral or remote argument, so there's no one to
Oh.
rebut. And I think
Okay,
we're limited
well.
to 15 minutes as a result, so we have
Okay.
5 minutes left.
Oh, okay. I guess this was extensively briefed. I don't know if anybody has any questions. No questions?
I don't have any questions. I don't know what that noise is.
I don't either, and that's why
Yeah,
I
no,
didn't
my
know.
apologies.
yeah.
When we stand still, I don't get it, so
It's not too loud.
it's okay, yeah.
Okay. Okay, I guess then I'll just go ahead and finish up. What we argued alternatively, obviously, our main argument is that the rebuttable presumption, the error here in the trial court was that the rebuttable presumption should not apply in this particular situation. I think that the statutory language is clear, and when you look at that, it provides for the 3107C1A situation. If they're ineligible, which is undisputed here, it should default to 3107D and not go through the rebuttable presumption analysis. This case is absolutely distinguishable from Bronson in that regard for those reasons. But alternatively, if this court disagrees with the position about the rebuttable presumption, we believe that the trial court should still be overturned based upon the issues with the affidavit that USA Underwriters brought forth to, attempt to bring the rebuttable presumption into play. There were issues with the basis for it. We believe it doesn't meet the court rules for affidavits. But in addition to that, we believe that if the rebuttable presumption applies in this situation, our argument should rebut the presumption that she was not eligible to make the selection in the first place. If you don't meet the criteria, she clearly did not. There is no disputed evidence on that fact. She did not meet the categories to make that selection in the first place, so it should default to unlimited. And the evidence of that should rebut the presumption, rebut their affidavit that, and I know the court has read the briefing. There were a lot of issues with that affidavit. There were issues with the premium that they were citing in this affidavit that they brought forth and what policy timeframe that came from. Everything conflicted. It was nonsensical and shouldn't have applied in the first place. But in the event that the court disagrees with the statutory construction argument that we've made, we believe that the trial court should still be reversed on this issue because we did meet and rebut that presumption of the affidavit with the evidence that she wasn't eligible to select it in the first place. So it should default to 3107 D, or excuse me, C 3107 C sub D, sub 4. So I thank you for your time.
Thank you. Any questions from the panel?
No, thank you.
Thank you very much. As
you.
well briefed, that matter has now been submitted. We'll move to item number 5, case number 373-683, Jones v. City of Flat Rock.
Good morning, Your Honors, and may it please the court, Carla Akins on behalf of the appellant. The overarching issue, and I know you all have read the briefing, is that the trial court basically acted as the fact finder in favor of the defendant. It broke one continuous retaliation story into isolated pieces, accepted the city's disputed version of events, and then used a timing only against Ms. Jones. There's a lot of back and forth in the case law with respect to timing and how much time is too much time has passed. And I think my issue is that if you're going to have timing, say that's not, if the timing is too far or too remote to support denial of summary disposition, then it shouldn't also be used to support granting of summary disposition in just one way. So here, I just want to go over the timeline just of events. So the first thing that happens is on April 4th to 13th, Mr. Bergeron makes the racial statement using the N-word. Ms. Jones immediately reports it, matters elevated to the city attorney, the mayor, and the police. Carrie Hammond then, May 6, 2022, asked the city attorney to consider having Bergeron recuse himself, because of the conflict and because he could not enter the center without an escort after this situation. June of 2022, Mr. Bergeron participates in decisions concerning reductions or restrictions affecting the community center and votes against an interim director measure. August 15th of 2022, he votes against Beitler's interim director appointment and against another center position. September 19th of 2022, he votes against Ms. Jones' full-time banquet manager position. And the key issue here is that the vote fails 3-3, which I think the trial court disregarded. But if his vote did not count, it would have been 4-2 in her. It could have been 4-2 in her favor or 3-2 in her favor if he had abstained. October of 2022, he votes against the community center budget amendment. February 6th of 2023, Ms. Jones' promotion again fails 3-3 with Bergeron voting against it. February 21st to 22nd, the council removes the requirement that it require the appointment, and Mr. Hawkins appoints Ms. Jones to the position immediately thereafter. March of 2023, Ms. Jones complains about her missing wages, summoned to meet, suspended, and is subsequently treated as having resigned or terminated. The first issue here is that the court drew pretty much all of the factual inferences in favor of the city. The court labeled the termination as arising from unrelated matters and accepted the city's characterization that Ms. Jones failed to cooperate with the financial investigation. It also treated the financial inconsistencies, the work schedule, refusal to attend meetings, and reason for discharge as established facts, which she disputed. And the court should have credited Ms. Jones' evidence concerning the suspension restrictions, her work schedule, the duties requiring client and email communication, which she was deprived of, whether she was resigned or was discharged, the absence of any substantiation of the claimed irregularities, and then Hawkins' testimony concerning the investigation and termination. Again, the 3-3 vote supports causation. The trial court disregarded this, but again, had that vote not counted, the point was that Bergeron's vote was necessary to defeat her promotions, not whether other individuals may have been controlled or influenced by Mr. Bergeron. It's whether or not his retaliatory vote caused an adverse action against her. Again, the court used timing as a one-way rule, and it's not the first time that I've seen this occur, but I think that, again, if timing alone is not enough to get past summary disposition, then it shouldn't have been used against her. And the record and the reason I wanted to lay out the timeline is because there's a pattern and series of events that all happened leading up until her termination, which is suspicious at best. And I believe that the court intervened and tried to make a determination that a jury should be entitled to make as to whether or not all of these events were related. I think it's significant. And again, if you're weighing credibility and you're weighing the evidence that supports that, whether or not the point is whether or not she has evidence to support what she's saying, not who has the strongest evidence, who has the most evidence. But the mayor coming out and supporting what she's saying gives credence to the fact that there was something suspicious about all these things that are happening that Mr. Bergeron is a part of, and there was no attempt whatsoever to distance him from any of these decisions.
If the protected activity occurred in April of 2022, I guess there's sort of two retaliatory instances, right? It's the votes, and then you claim the second retaliatory adverse employment action is the termination the following March, April, May of 2023. What's your best evidence of causation between the protected activity and the first alleged adverse action, which is essentially the votes preventing her from her promotion and the other votes, besides the timing? I mean, you mentioned the timing, you mentioned the floating of the idea of recusal. Is there any other evidence of causation between those two events?
So just so I'm clear, between the comment being made and then her first denial of promotion?
Or we'll lump all of the two denials or the votes. It seems like that's your argument, is the series of votes that happen after, or maybe I'm wrong. If you think, feel free to re-identify or reframe the issue. I guess my question is, the protected activity are the reports of the racist comments, and then we have to find evidence of causation between the protected activity and an adverse action. So I guess my construct is there were two adverse actions. If you have a different construct, that's fair.
Well, I guess three, the two promotions with the vote, the 3-3 vote in which the person she's complaining about is the one who's involved. And I think if you are requiring a person to have something beyond, I've complained about this person has taken no steps to get them off of, any decision-making related to him, then you're supposed to have an escort in the building and all of these things. The fact of other employees, and I don't want to misstate the record, but stating that they thought that Mr. Bergeron's conduct was questionable. And I just want to go back. So I have the complaint. 1 second. The timing is certainly suspicious, but I think it's the fact that he was the subject of the complaint. He knew about it. And he was described as changing his treatment because of it. And then he cast a necessary no vote on 2 3-3 promotion measures. And under West, which requires evidence that the protected activity influenced the action. And again, as to whether it actually did, I think that's a jury question. Does she present enough evidence to support that it did? And has the city shown that it didn't? I don't think that they have done that, especially with obviously her own testimony, but also which can be credited or not credited, but with respect to third parties indicating that they also had issue. They thought that Mr. Bergeron's conduct was questionable. I think that came from the Zick deposition concerning the suspension and reporting expectations and just all the activities that people did in between. There was enough other people to say that there's something wrong here. It wasn't just my clients, saying that there was an issue. The Beitler deposition, that's Exhibit F, about complaint-driven, changed, soured, tainted treatment of Miss Jones, testified as with respect to that.
But what about then as to the termination? I mean, then she actually was promoted,
Correct.
right? And then some period of time after that, I understand it's disputed what happened next, but what's the connection between the protected activity, the reporting the alleged racist comments to her termination?
Well, I think that make sure you can't lie in wait. And I think that's the Sixth Circuit case law. I want to make sure I get the right case there. That 1 second, sorry. Hamilton versus General Electric is the increasing scrutiny, the increasing conduct, the fact that there's a factual dispute as to all the things that lead to this termination, and they don't have anything to actually support it, and that there were continual things that happened. I think so often we get caught in the weeds of, the law says this, but it's a factual issue, right? Is there enough evidence for a jury to look at this and say, okay, this person has been functioning just fine up until this comment is made, and now, he needs an escort in the building, and then now he starts voting against her, and then we come up with some, right way to say this, a made-up reason, if you will, for why we're going to terminate her that doesn't actually have a foundation and nobody can actually support. So all of those things, does it look suspicious? Is there an inference of discrimination? That's the question we should be answering, not, having to try to separate. It's just not how it works in the real world.
I think I have the issue I have is that she actually does get promoted. Even though had she never gotten promoted, I could understand it. But ultimately, she actually does get promoted. And the person who's making the decision ultimately regarding employment is not the person who she had made the comment about. And so I'm not seeing the causation link that you are referring to. Had she not gotten promoted, had they gone and hired somebody else when given the opportunity to, I might have, I guess, followed that line a little bit better, but I'm having a real hard time with the causation between the fact that the person that ultimately is given the choice immediately promotes her. It's almost immediate. And then she is let go for a reason, but he is not the person who she had made the complaint against. And so where's the connection?
Well, I guess it comes back to, is there enough for the inference of discrimination? Because the defendants read the case law, right? So they say, well, let's get another person in here and let's have her promoted. And then when she comes into court, we're going to say, well, it broke the chain and therefore it's over. Well, you then came up with this reason for termination that doesn't have any support. You kicked her off of all of her devices. It's disputed as to whether she was terminated, she resigned, or whatever happened towards the end. And I understand that in theory, but again, if a jury's looking at this and they're watching the entirety play out, it still requires the court, the fact finder, to believe that that is the actual reason that they promoted her, because she didn't have any issue. They didn't promote her to try to make it look not retaliatory. If you're looking at the facts in a light most favorable to my client, which we have to, this is should not be a trial by paper, then at that point would we say, okay, well, and then just immediately thereafter she gets terminated under suspicious circumstances. And again, is it okay? So then They gave a legitimate reason. They tried to break the causal chain. Did it actually break? That's a question of fact. I don't think that we can say, I mean, that as a matter of law, you can say, well, all those other things are just discarded because we promoted her. If anything, it shows that Hawkins didn't have a problem with her when he had the opportunity to actually do something. But when it came back down to, we're going to let her go, it goes back to Bergeron and everybody else. And now and they wanted to get rid of her.
But if I accept your reasoning, why wouldn't they have just voted to approve it? Why let the motion fail again because if it's a split vote and then turn it over to Hawkins where he makes the decision? If I accept your reasoning, why wouldn't they just, if it's a conspiracy, wouldn't that have made the most sense?
Sure, if they don't have attorneys working with them. In a perfect world where everybody just, is good intentioned and does not care about these things, fine. But the reality of the situation is from day one in most of my employment cases, well, really day zero, before I ever get involved, there's a defense lawyer informing arbitration agreements, shortening the statute of limitations. All these things happen before I ever get there. I've had some cases where, the lawyer might have been the one that actually told them to let him go. Who knows? The point is that, does it look suspicious? And that's the whole inference of discrimination, so that we're not saying, well, this broke the causal chain. Maybe it did, but maybe it didn't. Is there enough evidence to say you set this up so that we would be right here, the case would get dismissed, and then nobody would ever get to see, do I actually believe that the reason you promoted her was this? Do I actually believe that the reason you terminated her was that? And so then it comes back to, what does the totality of the evidence, rather than trying to take it all apart on paper when nobody's heard from these people, right? I mean, that is the reality. And I think that's what's so dangerous about taking credibility and trying to make an inference as a matter of law that a jury could look. Because what you're asking is, could a jury looking at this say the opposite? That's what we should be saying, right? Could a jury looking at this say, you know what? I see what they did here. I think they did that in order to prevent her from getting to a trial, or resolving whatever, from getting past summary disposition on her claims. And so therefore, because immediately thereafter, now you have this very odd termination resignation scenario, which again should give that inference that something's up. Okay, yes, you promoted her right then when he had the opportunity to do so, but as long as Bergeron wasn't involved. And as soon as his involvement is now, full board, we're going to let her go, all of that, and we're going to put in a person. I mean, we see it all the time, unfortunately, that we're going to put in a person who's going to break this chain and make it look like they had nothing to do with one another. Will a jury believe that? I don't know. But the point is, the jury should have the opportunity to say, I believe that that's actually what occurred, and that Hawkins worked alone and had nothing to do with any other decisions related. Because the reality is, in an employment case, the employee's never going to be able to show that somebody had noticed or knew about all the things, because nobody's going to come in here and tell you that, you know what, we talked about it. We decided we're going to promote her and then we're going to fire her. So the jury, though, can look at this person and say, you know what, I don't believe them. I don't think that they just promoted her just because now all of a sudden we think it's fine. If anything, it shows that Bergeron was interfering in the promotions before and had, so if we're going to separate them out, okay, if it's termination and you all have an issue with that, that at least these prior actions were emblematic of the problem, that she complained, these actions start happening, they continue to happen, they find a reason that they think is legitimate, but they don't actually try to legitimize it, and then they terminate her. And that's the story that we would be presenting to the jury, and I think she should have an opportunity to do so. Any other questions? I don't know how much more time I have. I wanted to reserve some.
Okay. Do you have any questions?
3 minutes.
No more question right now.
There's time reserved.
Okay, thank you.
Thank you. Like,
Good morning. I'm Stacy Belisle, representing the defendant, Applee, City of Flat Rock. I know that we've briefed all the issues that have been brought up here today, but I just wanted to highlight a couple that I think are really important. Number one, the timing. The city council was never happy about the community center. And that is stated in a timeline in our brief. Back to 2020, they didn't like it. They were continuously transferring money out of the city's general fund to fund the community center. But people wanted it. People wanted to have it. People wanted to have parties there. So, but as to issues only arising relative to the plaintiff and the community center and votes against the community center only arising after she made a complaint regarding Councilperson Bergeron, that's just not the record. The record is that based on meeting minutes, numerous meeting minutes, the council just did not favor the community center. They didn't like it. It was taking up too much money. They were having to fund it. It wasn't supporting itself. It should have been making money. There should have been some money coming in from it, but it wasn't supporting the venture that the city wanted to have. And so there was always a problem with the community center.
But what does that have to do? I mean, that seems to me to be evidence potentially of a legitimate non-retaliatory reason. It doesn't, in my mind, actually undercut causation or the potential. I mean, you don't dispute there was protected activity, right?
I dispute that she is a protected individual under Elliott Larson's Civil Rights Act. She has
That's
no
for-
protected category of her own.
That's why I
She-
asked
she
about
re-
retaliation.
Yeah, she reported some information.
Okay.
But to my second point, which I think is really important, is that throughout our brief, we noted that there's no evidence, and to some of the points made here today, there's no evidence that Councilmember Bergeron influenced anybody as to any vote. And that's plaintiff's own testimony as well. I asked her point blank, do you know if Councilmember Bergeron told anyone or influenced them or, had any particular influence on anyone to make any vote regarding you or Mr. Hawkins relative to your employment? And her answer was no. And that's critical for a causal connection between any retaliatory action by him and her conduct relative to his comment. So the council members can vote however they want, but if there's no connection between him saying, well, okay, so I really, really hate her now because I'm obviously exaggerating, but I really hate her now because she made this complaint about me. And, we need to not fund the community center any longer. There's just no connection there. That combined with the fact that the council has never been in favor or has been split certainly relative to the efficacy of the community center demonstrates there's no causal connection and no retaliatory motive on his part.
I guess I view the votes about the budget and the funding differently than the votes as to Ms. Jones's promotion. I mean, I know they're all votes, but they're different, right? I mean, some are, that's why I asked the question of the plaintiff's counsel as to, and then where I was trying to go with you, we have protected activity, a complaint made, we have adverse action, which is 2 votes, and then, against her promotion and then termination. And that's why I asked plaintiff's counsel what I did about causation there. But really, all your argument about the funding, I mean, you say council members can vote however they can vote. They also can recuse themselves, right? They also can not vote if there's an issue. And so to me, that I guess my question ultimately is should we view the votes about the budget and the funding through the same lens that we view the votes as to Ms. Jones's promotions? I think they're different.
I think they're absolutely the same. I think it is a longstanding difficulty on the part of the city council as to the community center. They didn't want to fund it. They didn't want to transfer any more money. And of course, in connection with promoting someone or moving someone into a position, there's going to be an additional transfer of funds. So to the point of the court that was made earlier with counsel, plaintiff was ultimately promoted. They just put it in the hands of someone else. And then he, of course, had the legitimate, uninfluenced, legitimate non-retaliatory basis for terminating plaintiff's employment, which was that he said, listen, we've got some issues coming up with financial irregularities. Please come in to see me. And she said no. And She could never be interviewed. She wouldn't speak to that. And she didn't come back the next time she was scheduled to work. And of course, Mr. Hawkins, who unfortunately is now deceased, but we do have his deposition testimony, determined that she was no longer employed with the city. There was no evidence on the part of anyone that he was somehow influenced by Mr. Bergeron in making that determination. In assuming that she had self-terminated, or if he did terminate her, there's just no evidence of that by anyone. And there were multiple people deposed in this case. So that's the break in the causation. There has to be some sort of evidence that Bergeron had an influence over people and that his retaliatory animus influenced people to vote in a particular way, or for Mr. Hawkins to terminate her, or for Mr. Bergeron to have gone to Mr. Hawkins and said, look, she's, a terrible person. We've got to get rid of her. There's just no evidence of that at all. Yeah, the Heather Beitler Depp, I mean, she has no supervisory position. She's not on the city council. She has no regular communications with the city council members. So her opinion is her opinion. But again, much like the other evidence that I've discussed here today, there's no evidence that supports her statements. And if we're judging the evidence in the light most favorable to the plaintiff, Heather Beitler just has there's just no evidence supporting what she said.
I have a question about the Civil Rights Act versus the Whistleblower Protection Act for purposes of the retaliation claim.
Mhm.
Is the analysis different? I'm struggling to look at them and understand how they're different. I mean, I could see where they apply in slightly different situations, but
Yeah.
for purposes of this case, are they?
They're sort of duplicative. So under the Whistleblowers Protection Act, you engage in one of two types of protected activity, either reporting what you believe is an unlawful act or participating in an investigation regarding an alleged unlawful act. Under Elliott Larson, if you believe that there's been a violation of Elliott Larson, you engage in protected activity by reporting that alleged violation of Elliott Larson.
So the legal analysis is the same. That
It's pretty much the same. It's just a little bit different in terms of what you're reporting. So under the Elliott Larson Civil Rights Act, you have to believe that you're reporting discrimination that would violate that act. Whereas if you're reporting under the Whistleblowers Protection Act, it doesn't have to be a violation of the WPA.
okay, just to clarify, Mike, I guess, so the substance of what constitutes protected activity could be different, but the legal analysis that we have to go through in terms of protected activity, adverse action, and causation is the same.
Basically.
Thank you.
I'm happy to answer any other questions.
Any other questions?
All right, thank you very much.
Thank you very much. Good.
Thank you, Your Honor. I think that the argument from the defendant just sets forth that there's a lot of factual disputes. This whole thing of they just didn't like the center. Well, there is evidence with respect to Ms. Beitler. I mean, again, they're asking you to disregard somebody's testimony saying there's no evidence of it, but that is evidence, somebody testifying. She said the complaint affected, soured, tainted, changed Mr. Bergeron's treatment of Ms. Jones in the community center. That's at 26, 27, 28, 29, 34, 30.
Is saying, a racial slur is horrible. Is it a violation of either law or ELCRA in and of itself?
To do what? To say that?
Yeah, for a racial slur and conversation outside of any main proceedings.
Well, I think ELCRA covers like an action that happens as a result of it, or like a hostile work environment claim as a result of that, if that's what you mean. So yes.
The city council member created a hostile work environment based on that claim.
Based upon the retaliatory environment that resulted as a result of that, yes, in terms of her work environment there. And I think that's what the testimony is from the colleagues and then from the mayor, that Mr. Bergeron's treatment of Miss Jones was more scrutinized and it got worse, even with respect to the center taking it out on him after she made this complaint. I mean, I understand it. I mean, he's, you know, having to have an escort and all of these things. I think he felt he was comfortable making a comment like that, and she was not comfortable with it. And then as I went through all the different actions and things that took place, but she testified with respect to the environment becoming hostile after that. Mayor Hammond said that the repeated inability to get Miss Jones' salary or promotion measures he thought was unusual compared with other departments. That's his deposition at 25 to 26 and 35 to 37. So it's not just that they didn't like the center. Again, there's competing evidence. I'm not asking you to believe Miss Jones. I'm asking you to say that a jury could believe her and disbelieve that what the defendant is telling you. The ELCRA, to that point, the causation ruling was sua sponte. The court recognized that neither party had raised ELCRA causation and then decided the issue against Miss Jones. We didn't have an opportunity to brief that. To Your Honor's question with respect to the analysis being the same, sometimes there's case law that supports that it is, and then sometimes depending on, you know, what the adverse action is, because, for example, we've had the U.S. Supreme Court case with respect to what constitutes an adverse action has expanded. Has there been comparable case law about under the WPA about what constitutes an adverse action? No. But, you know, a lot of times the analysis does kind of go together, if you will. But I wouldn't say it's exactly the same. But for our purposes, I think, again, we didn't get to argue the ELCRA causation point because it wasn't briefed. To Your Honor's point, I wanted to consider a little bit more with respect to the financial investigation, severing the termination. Again, the point is that the city subjected Ms. Jones to heightened scrutiny and then used this financial, you know, allegations to get rid of her and complete this ongoing retaliatory course. That's the theory that she's espousing. And that's under Hamilton versus General Electric out of the Sixth Circuit, with this increased scrutiny following protected activity together with disputed grounds for termination could support a jury question. And the questions are, was there an audit or completed report relating to these financial issues? Were the alleged irregularities actually substantiated? Was Ms. Jones even scheduled to work? What could she do while she was suspended? Was she expected to work while suspended without pay? Did she resign or was she discharged? All these things are still in dispute. Defendant for sure has not, as a matter of law, definitively determined those. And I want to address the point about her refusal to cooperate. I just want to be clear, that was from the trial court's, I guess, statement with respect to that, but she does not agree that she refused to cooperate. Ms. Jones missed an initial meeting for personal reasons. The city then suspended her without pay, restricted her from using email, from contacting clients, requested another meeting while she was suspended. So the parties dispute what a suspended employee was expected to do, whether she was even required to report, whether one alleged absence occurred on her scheduled day off, and whether the final separation was a resignation or a discharge. So our position is that these disputes cannot be compressed into some undisputed finding that she refused to cooperate, and therefore that was the reason that they terminated her, or that she left, or again, nobody knows exactly what it is that actually happened at the end. So in general, again, we're not asking you to find in favor of Ms. Jones' version of events. We're asking you to find that there are disputed versions of events that a jury should decide was the causal chain broken, and that at the very least, that is not a question of law. Thank you.
Thank you very much. The matter has now been submitted. We will turn to item number 6, case number 375100, Melton v. Zieta. Whenever you're ready.
Good morning, Your Honors. Just barely. May it please the court. I'm Grant Jaskolski on behalf of citizens. In this case, Progressive listed Thelma Melton as eligible for PIP coverage on its declarations page. It included her as a named insured on the certificate of insurance. And most importantly, it kept all of the premiums to cover her for that insurance through the date of the accident. I think under these circumstances, Progressive should be responsible for her PIP benefits, and it should be then reimburse Citizens for the benefits that it has paid to her under the assigned claims plan. Just looking at the deck page and the certificate of insurance, she's listed as eligible. She's listed as a named insured on that certificate of insurance, and she was charged, or Progressive charged a premium for that coverage. And when an insurance company collects and retains a premium, it cannot later disclaim coverage. But that is exactly what Progressive is trying to do here. It kept their premiums through the date of the accident. From 2020 through 2023, it charged premiums for Melton's PIP coverage. But once she's involved in the accident and then makes the claim, it removes her from that coverage the day after the accident. The declarations page that was still effective on the date of the accident wasn't amended. It still lists her as eligible for medical benefits. And regardless of why she might have been listed on there, Progressive listed her as eligible, and it charged and retained a premium for those benefits. So if they want to say, well, this policy was procured by fraud, and that's the only reason that she was listed on there, they had other remedies to do this other than after the fact, just removing her from coverage and saying, well, we don't owe you any benefits under the statute, even though we said you were insured on our declarations page and in the certificate of insurance. They could have refunded all of the premiums related to her coverage and basically set this up like she was never insured in the first place. They didn't do that. They changed it after the fact, retained the premiums. They could have rescinded all the coverage. They could have reformed the policy. Why they didn't do that, I'm not totally sure. But really, an insurance company cannot charge a premium, retain that premium, and disclaim coverage.
Well, if they had rescinded, the analysis would have been a little different, correct?
It would have been different. But they could have also reformed the policy. They could have said, let's just remove her from, let's act like she was never on the policy because she never should have been on the policy, which is their position. They could have then said, hey, Bossy Baker, here's your money back. She's not insured, but your car was insured, but she wasn't. And then they could figure it out from there. But they didn't do that. That's the big problem here is they've just kept the premiums. And then they're trying to say, well, we don't owe coverage now. And that's really what this whole case comes down to is they were paid premiums for this coverage. They shouldn't be able just to disclaim coverage after the fact. Beyond that, the only other thing I would really just add is just the jurisdictional issue that was brought up in Progressive's briefing. Those final orders, the order dismissing the case and the order refusing to reinstate the case, they were final orders. It was made clear by the order denying the motion to reinstate where the judge said, hey, this matter is resolved. There's nothing for me to rule on. Even if it might have said without prejudice, it really was disposing of everything. There was nothing else for the trial court to rule on. I think under these circumstances, it was a final order. The claim of appeal was appropriate. And even if it was not, at this point, in the interest of efficiency, this court should treat that as a application for leave and granted application for leave and rule on the substantive merits to hold that Progressive is responsible for the PIP benefits here.
Any questions?
No.
Thank you.
Thank you.
Good now afternoon, Your Honors. Just checking after. Neil Hansen here for Progressive. Couple quick points. I'm not going to restate everything in the brief either. I think it's very well briefed on both sides, but really there's an overstatement of facts here. There is a significant overstatement of facts because all that matters is Thelma Melton was in this March 17, 2023 accident. At the time of the accident, nobody disputes she lived with Mr. Baker. He's Progressive's named insured. But he chose, for whatever reason, that is not my client's problem, to list that he was married to Miss Melton on his policy application. He was not. That is not in dispute at any point in time. They lived together. They were purely boyfriend and girlfriend. Those are really the only relevant facts to the motions that were filed in the trial court. Progressive's motion was very straightforward. We are not in the order of priority under MCL 500.3114. I don't see any response substantively from Citizens disputing that. We're not. She is not the named insured on the declarations page. That is the first way we would be under the order of priority under section 3114. She is not that person's spouse, and she is not a resident relative domiciled in the same household. That is irrefutable, and I don't see any response from them opposing that. So if we're not statutorily in the order of priority, the only manner in which Progressive could possibly have to cover this claim is if its policy contract with Mr. Baker went so far as to cover her despite the statute not requiring it. And it doesn't. The only relevant considerations on the language of any of the Progressive documents are what the policy says about who's covered. It specifically defines who is covered, for PIP benefits at least, as eligible injured persons. And there's only two definitions, and they're very simple. The first one is a big, bold, black word in the policy that says you. And that is defined only as the named insured on the declarations page. Nobody here disputes that the only named insured on the declarations page is Mr. Baker. It is not Miss Melton and that person's spouse, which again, they're not married. The second definition of eligible injured person on the contract is a relative. Relative is defined only as a person, paraphrasing, residing in the same household as you, i.e. Mr. Baker, the named insured, and related to that person by marriage or blood. It is undisputed that Miss Melton is not that. So we have those as the clear, unambiguous terms of the policy contract Progressive issued to Mr. Baker. They don't cover her. It's that simple. What Citizens is really here arguing is, well, there was an extra $117 that Progressive collected because Mr. Baker made a mistake and chose to say that he was married to Miss Melton. And respectfully, I have sympathy for him, but that's not relevant. I mean, he made a mistake. He chose to do that. It doesn't change the fact that Progressive doesn't have an obligation under its contract terms or the statute to cover this claim. And I don't remember if I actually cited this example in my brief, and I don't want to get too far into the weeds, but I can't think of another walk in life where if someone makes a mistake like that, you would then turn around and say, it's not your fault. If I pay Netflix for 4 screens and I'm only using 2, and I tell them I'm using 4 and they charge me, do I get to go back to them later and say, my fault, give me the money back. I was actually only using 2. He made the mistake. So regardless, I don't think that's a basis to argue that Progressive has to cover this claim. There's nothing in the no-fault statute that would put us in the order of priority purely because the named insured made a mistake when he filled out his application and ended up paying an extra $117. That has no effect whatsoever on MCL 500.3114. There's nothing in the contract that says because the named insured made a mistake and was charged an extra $117, this person is now an eligible injured person. So I don't think that payment really has anything to do with anything. Frankly, it's just extraneous facts that don't change the fact that the contract and the statute don't require Progressive to cover this. I know they cited some cases and they talk about repudiating the contract, but that's not what we're doing. The contract just doesn't cover her for PIP benefits. There's no reason to repudiate it. And there was an adjustment and she was eventually, the premiums were eventually changed after this was discovered. I think counsel referenced, well, Progressive had this policy in place for this long, for this many years, and never did anything. Of course they didn't. They didn't know about this until after the accident happened. And Miss Melton said, oh, by the way, I'm not married. And an insurance company has no obligation, we've cited the case law, to go back and investigate the accuracy of statements made by the named insured. Nobody'd get insurance. I mean, what are they, every time somebody applies, are they supposed to call back and say, are you sure you're really married to this person? I mean, it's extraneous arguments that go outside of the very simple arguments that were made to the trial court. Are we statutorily in the order of priority? The answer is no. Does the policy contract require us to cover this? The answer is no. And the cases, again, they cited, I forget the names of them. One of them was almost 100 years old. I think it was Rourke. And then the other one was the Burton case. Those are both rescission cases, but this isn't a rescission. There's no rescinding the policy. We don't need to rescind it. We're not required to rescind it. If the policy contract simply doesn't provide her coverage, it doesn't. And it's not as if this is illusory. She would be covered for other things on the policy. She's covered for liability insurance. She'd be covered for collision damages. It just so happens to be that the contract terms don't cover her for PIP benefits. The other point I just wanted to make was there was a mention regarding the information on the declarations page about it saying that she's eligible for medical expense coverage. That designation is purely in response to the 2019 no fault amendments where individuals could opt out of having medical expense coverage on their policy. All that means is that Mr. Baker did not opt out of having medical expense coverage on the policy. And in fact, if he had been telling the truth and Ms. Melton was actually his spouse and Progressive was in the order of priority, the medical expense coverage would be there because there isn't an opt-out. That has nothing to do with priority. That has nothing to do with requiring Progressive to pay her PIP claims under the contract. I just gave you the definitions of eligible injured person. They do not include a definition that says someone who is listed as eligible for medical expense coverage on the declarations page, because that's not an eligible injured person. It's simply a designation saying nobody elected to opt out of medical coverage. So I don't think that's also a basis to find that we would have to cover this claim. I don't have anything really to add regarding the procedural issues in the final order other than what's in my brief. The only point I would like to make is it wasn't raised as a mere technicality here. After the trial court granted Progressive's dispositive motion, citizens made a voluntary decision to pay the claims and settle the case. They could have gone to trial. They could have won the trial, in which case all of this would be moot. They could have lost, at which point they could have brought this as a claim of appeal. And if your honors did in fact reverse the trial court's ruling on priority, Progressive would still have an opportunity to assert its other defenses to these claims, of which there would be many. Some of the claims would be time barred. Potentially, they could consider rescinding the policy. That wasn't a discussion that ever needed to be had. But now, because they chose to just pay these claims, that's all off the table. They did this in a bit of a roundabout way that deprived my client of having the opportunity to raise any defenses substantively to the claimant's position. Now they're just going to turn around if this is reversed and say, well, the statute says you have to reimburse us, so pay us everything back. And that's, frankly, that's just not fair. There was a better way they should have done this. So beyond that, I don't think I have anything else really to add unless anyone has any questions.
As briefed and argued very well. Thank you.
Thank you.
Any questions?
No.
You have plenty of time for a while.
Yeah, just very briefly. Progressive just wants to ignore what's said on the declarations page where it says eligible for PIP medical benefits, yes. And hiding behind this, well, they didn't opt out of the policy, that ignores how they changed the declarations page after the accident. Because she still didn't opt out of PIP medical coverage or opt out of anything. She was under their position, not insured at all. But now she's listed on that declarations page, eligible for PIP medical, no. So how can it be this just means that it's not an opt-out policy or is an opt-out policy when they make that change? And again, they only make that change after the accident. And I do just want to also add when they learned of the mistake, they only changed it after the accident. They didn't change anything before the accident. I can't just emphasize that enough. And as far as settling this claim after before the trial and anything like that, there's no gamesmanship there. This was a straight reimbursement action under 3175-2. Citizens, as the servicing insurer, has the obligation to pursue that reimbursement right. The case law is very clear that that is independent of the injured person's right to claim benefits. So whatever defensive Progressive theoretically might want to have raised against Thelma Milton beyond just this priority issue, they would not be able to raise that in a reimbursement action. Had we entered a stipulated order of dismissal, filed a claim of appeal, we could have raised this exact same issue, done the exact same way. And had you said, well, actually Progressive is entitled or is obligated to reimburse citizens, they'd still be obligated to reimburse citizens just the same way that it is now, regardless of how we got here. And that's how this court should hold. And unless there's any questions, I think that's all I have.
Any questions? Any questions? Thank you very much.
Thank you.
The matter has now been submitted. Our last case of the 10 o'clock session before the 11 o'clock session is item number 1, case number 375201, People v. Teddy Jr.
Good afternoon, and may it please the court, Jonathan Simon on behalf of Mr. Teddy. This is a CSD2 case involving a 6-year delayed disclosure. The first argument is that there was some effort by the prosecution to elicit from one witness an opinion that another witness believed that Mr. Teddy was guilty. Now, I had phrased the issue in terms of it being cross-examination of my client's wife, when in fact it was actually direct examination of the complainant's aunt. And I regret that error. And its prosecutor calls it mischaracterization. I think it just simply got the facts a little bit wrong, but the principle remains the same. It is improper to solicit an opinion from a witness about the opinion of another witness. And I believe that that was prejudicial. I believe that it should have been objected to. Counsel failed to do so. I think it made a difference, and I think that it was outcome determinative. Now, the closing argument, the prosecutor told the witness, well, look, one person says this, one person says that. You have to decide who's telling the truth. When that's, as I see it, a distortion of the burden of proof. The responsibility of the prosecutor is to persuade the jury that there's guilt beyond a reasonable doubt, not whether one is telling the truth and one is not telling the truth. And so I think there's a distortion there, which cries out for some relief. Now, an interesting issue is, I think, the third one, which is a sentencing issue, because the allegations were that Mr. Teddy came from the bedroom, approached the complainant who was on a sofa in the living room, retreats, comes back, retreats, I think maybe as many as 5 times. And then, and for that reason, Mr. Teddy was assessed 25 points for offense variable 12 for multiple acts. But it is our argument that it is one contemporaneous felonious act, and it was the body of the evidence, because in the closing arguments, the prosecutor says that this is what proves the intent to commit a criminal sexual conduct. And so we argue here that it is not contemporaneous acts. It is actually the act of attempting to use to prove intent. Now, as to the final argument, whether lifetime electronic monitoring is cruel and or unusual punishment or an unreasonable search, that issue was raised because at the time the Michigan Supreme Court was considering that issue, which the Supreme Court has already decided, and it wasn't favorable to the to that claim. However, it's my understanding that there is another case now before the Michigan Supreme Court, which is also considering that very same issue. So I think maybe perhaps because that issue is still subject, I think, to some degree of consideration by the higher court, perhaps this court should allow that Supreme Court to weigh in on that issue before making any decision as to the legitimacy of lifetime electronic monitoring.
Thank you, Mr. Simon. I know this was the first matter on the docket, and due to no fault of your own, it got pushed to the last, or the first matter in the morning. So thank you for your patience.
Yeah, unfortunately, Ms. Stone also had a case high on the 10 o'clock docket across the hall, and she was attending that, and that's how things happen. But it's okay because we both had cases on the 11 o'clock docket as well, so we would have had to be here.
We will see you again soon.
Yes, thank you, Judge.
Good afternoon, Your Honors, and may it please the court, Ashley Stone from the St. Clair County Prosecutor's Office on behalf of the people. I wanted to start by thanking the court for your courtesies and also the assistance of the court officers. I have 5 cases between the 2 panels today, so trying to be many places at once has been a challenge. Everyone's been very courteous, and I appreciate that. But I will be brief. On appeal, defendants' claims of prosecutorial error are based on, I guess, the inherent disagreement about what the proofs show or mean in this case. Credibility was a key issue for both parties. In terms of the first issue raised, I think that the defense placed the dispute between the complaining victim IRF's aunt and her other aunt, who happens to be the wife of the defendant, at issue because they argued that the allegation of criminal sexual conduct arose simply as a result of family dysfunction, that this child had been coached to make these complaints and things of that nature. And so inquiring about the family dysfunction when there was a break in communication between the two sisters, I think was a fair issue to ask about on the prosecution's behalf. And I think that they explored that without eliciting an opinion on the defendant's guilt. That is probably my main disagreement, is I do not think when you look at the transcript here that the questions asked elicit this witness Clearwood's opinion about the defendant's guilt. So as a result, I don't think that there was any ineffective assistance of counsel for not objecting to that question or any prosecutorial error related to it either. Similarly, in closing argument, the prosecution argued that the jury needed to evaluate everyone's credibility, and they used terms from the jury instructions to do that. It's consistent with the jury instruction, how we talk about credibility of jurors, and I think in no way was it improper or otherwise vouching. The third issue regarding the scoring of offense variable 12, I believe that's properly scored. Those other distinct acts of touching could have warranted or been other charges.
Were they used together to prove sexual purpose?
There is a comment in the prosecutor's closing that of course this was for a sexual purpose, and you can see that in part in the pattern of him coming back. So that is part of the prosecutor's closing argument.
Those are part of the proofs for that count.
See, I guess I would disagree or make a distinction. But I think you can say this is for a sexual purpose. What other purpose does a grown man have for sneaking out in the middle of the night and putting his hand up an 8-year-old shorts and touching her vagina? Any other excuse he might have had for what that purpose would be is belied by the fact that he kept coming out. Every time he was caught, every time he thought she woke up, he kept coming out.
I think it could have been prosecuted differently as separate charges potentially, or argued differently. But in this case, it seems like it was used as proof for the one offense that was charged.
And maybe this is where we just have a, I guess a different, I'm trying to find the right word, conception of it. Yes, I think the multiple touches are used to bolster the idea of sexual purpose, but that doesn't negate that they are other unconvicted, uncharged conduct. I don't think that's the only proof you had of sexual purpose that would make it the body of the offense or the only proof of that element that otherwise takes it out of consideration for OB-12 purposes. That said, if this court disagrees, I do believe it triggers resentencing. But lastly, regarding the lifetime electronic monitoring and whether it's cruel or unusual punishment, I agree. When Mr. Simon originally briefs this, it was pending People versus Cardaz and People versus Martin. The Michigan Supreme Court has since denied leave on both of those cases. And in Martin in particular, the court noted that they're bound by the lifetime electronic monitoring analysis in Halleck. And I think that's important here because this case has all the hallmarks that Halleck had in terms of the gravity of the offense, the harshness of the penalty, and the proportionality test here. You have someone that is engaging in predatory behavior against a vulnerable child. There's a significant age difference. The complaining victim in this case was 8 years old at the time of it, and he's in a position of authority or a trusted adult when it happens. And so in terms of a as applied challenge, which is really, I think, the only thing on the table at this point, I don't see that this falls within the framework of what would be cruel or unusual. The people do note in their brief that People v. Ringel is, I believe, currently pending on application grant in the Michigan Supreme Court. And there's, again, another similar challenge to lifetime electronic monitoring raised in that case. With that, Your Honors, I know it's been a long morning and there's more to go, so I will rest on my briefs unless there's any other questions I can answer for this court.
Any final questions?
Thank you.
Thank you very much,
Thank you, Your Honors.
Mr. Simon.
respect to the closing argument, while I did cover the distortion, I think, of the burden of proof, what I neglected to mention is that we also challenged the vouching by stating that he believed the complainant was telling the truth.
Thank you very much. With that, that matter has now been submitted. We will take a brief recess before the 11 o'clock. All right, thank you for your patience. Welcome back. We're ready to start our 11 a.m. session. One brief thing, please remember that because the proceedings are recorded and published publicly online, council should not use the names of minors or other vulnerable individuals. I always struggle to say vulnerable. We will now call item number 7, case number 374-581, Smith's Designer Construction v. Ellis.
Good afternoon. Beth Whitman appearing on behalf of the defendant's third-party plaintiffs, the Ellises. Ms. Ellis is actually here in the courtroom with us today. In this case, obviously, yes, I believe counsel for Smiths is remote.
Okay, let's make sure if counsel is in the waiting room, there'll be a. Okay. John shoots.
At least I know he did a request for.
Yeah, I see
remote
that. We
audio.
granted it. So I just want to make sure if he's in the waiting room. Is there anyone in the waiting room?
They can hear us, and so they can hear us. We can talk to them, glance and listen to us, so they have.
Yeah, him on. I just want to make sure he's actually in the waiting room, so. Should we?
And can somebody respond from Lansing and let us know if there's anyone in the waiting room or not? Or if there's a technical issue?
I'm sorry about this.
No, that's fine. Of course,
It may, do we have other remote just to make sure? Yeah, we do for case number 10 as well. So. Without confirmation from them, I'm just a little hesitant. So maybe we'll do case 8 and
Okay.
then return to case 7 once we get notice. And in the interim, if we could call or just contact Lansing to. My apologies for that.
no problem. I appreciate
Sorry.
it. Okay, thank you.
So we will instead call item number 8, case number 375-797, King v. Members Select Insurance Company.
Good afternoon, John Knockisel on behalf of plaintiff appellant. I'm going to do my best to keep this one brief, but I will go over both the procedural issue that you asked for supplemental briefing on, and then also get into the supplemental sorry, it's been a long day, but then get into the substantive issue second. But before I even get into that, I would ask that regardless of what the court decides on either issue, please rule on both. Even if one's, only as an alternative grounds, just so we have a clean record, should anything need to happen to get this case fully resolved via settlement or further appeal. As far as the procedural issue goes, the stipulated order was between the same parties, which at least nominally would put it in the realm of Stanley. However, I think there's a clear distinction that can be made when the stipulated order that was the final order in the case was only on the issue of the PIP claim. The UMUIM case had already been dismissed. That was gone. All that was in contention at that point was PIP, with the knowledge that then, yes, there was going to subsequently hopefully be this appeal that we get into the UMUIM issues. I think that puts it squarely in the category of what Jabber was discussing, when Jaber said that, the stipulated order doesn't have to have some sort of magical language or other sort of, specific call out to preserve an issue for appeal, and that basically the court should look at what the actual issue is and decide, was that subject to the stipulated order or not? In this case, I don't see how the UMUIM issue was at all subject to, like, it was not even contemplated in the release agreement or in the stipulated order resolving the PIP claim. And I think there's definitely a distinction at a minimum that can be raised there. And frankly, I think that because Jaber came out first, Stanley, to the extent it contradicts it, needs to be overturned by this court or the court of Supreme Court. Any questions on that issue before I move to the substantive stuff?
No question. Or, it says no questions.
Okay. Substantively,
It looks like this got working. That's why
okay,
I was thrown off for a second. Sorry.
no worries. Substantively though, the big thing for me is I don't think it can't be reasonable to expect someone who didn't have access to the policy because it was his mom's policy and who's 6 days in the hospital, multiple surgeries, to go get a police report immediately after he gets discharged from the hospital seems to be what they're asking for, when he didn't even know he needed to do that to comply with the UMUIM provisions because he didn't have access to the policy with that provision in it. There was a call, 911 call from the scene. It's not in dispute that he was involved in the crash or that he got hit by a hit and run driver. He was catastrophically injured. EMS came, took him right to the hospital. The only thing I can see, and it was the only point that defense counsel made in his brief that tripped me up a little bit was, okay, well, the police, had they come out, they would have, or had, a report been made, maybe they would have investigated and been able to, locate the hit and run driver. We'd have a defendant, maybe we'd have a BI policy. Police didn't even show up to a 911 call hit and run with a guy that might be dying. I don't know what a week and a half, 2 week later report would have done to force them to investigate this any differently. My client can't control the police. The police decided not to show up. They had other things to do, or they just didn't want to take the call, whatever it is. I don't know why a written police report 2 weeks later would have made a difference in any material way. With that, I'll save my time for rebuttal.
Thank you very much.
Good afternoon, Your Honors. Matthew Nichols appearing on behalf of the defendant appellee member select. May it please the court. I'll be brief. I know this case has been well briefed by both brother counsel and myself, I believe. So I won't repeat too much. I do agree with brother counsel as to one thing, and that is that the court can rule on both the jurisdictional issue that it's raised sua sponte, as well as the issues on the merits of this appeal, UMUIM claim. Other than that, I disagree with my colleague on all other grounds. But as to jurisdiction, as my colleague has pointed out in the supplemental briefs, we did concur initially with plaintiff appellant's statement of jurisdiction. That is correct. We did do that. But as the court knows, the court on its own can raise jurisdiction sua sponte at any point in time during the appellate proceedings, which it has. We ask that the court adopt our arguments in the supplemental brief, applying Stanley to this case over Jaber. As to the merits of the UMUIM issues, there's really nothing new, at least as far as case law from this court on the topic. I know we've cited cases from a span of 2011 in Dufresne through as recent as last year. I think that was in Hall versus Auto Club, where this court, neither a published decision or unpublished decision, has addressed squarely the same arguments and issues that are before this panel today. That is the arguments that the insurer must show prejudice when a claimant doesn't comply with these conditions precedent. That was addressed in Dufresne, the published decision. That is not a requirement. That member selects policy is somehow ambiguous. That's been addressed by Pitts versus Bostwick, Butler versus Lane, and Adams versus Allstate. Pitts saying the 24-hour written report requirement, quote, could not be clearer. I think
the issue of whether these policy terms are ambiguous have been settled by this court. Turning to the failure to make a written report to law enforcement, that's been addressed in Hensley versus Auto Club and Hall versus Auto Club. Member Select being part of the Auto Club group, the policy provisions in those cases are substantially identical to those here. Those decisions show that making a report outside the 24-hour notice requirement is insufficient, and that a telephone call to police rather than making a written report is also insufficient. So what we have here is a combination between a bystander who called 911, who didn't witness the hit and run accident, his or herself, with the written reports that were authored by the fire department and or EMS. The combination of those two still doesn't get plaintiff to the threshold of a written report to law enforcement.
Just to be clear, the definition, I guess, of written report in the policy, does it require the injured person to personally do the writing or typing here? Like, or is essentially would a DPD report taking a statement from the person who's injured? Is that what you mean? I mean,
I think it's making a police report. So whether that's calling.
because it says written report. So, I mean, you could say, well, he didn't personally write something down, so he didn't make a written report. That's not what you're saying, right?
No, because the claimant themselves can't make the written report. The written report has to come from law enforcement themselves. So whether that's through calling the police department saying, I would like to make a report of a hit and run, or going to the police station in person and filling out the appropriate paperwork. Neither was the case here. And what could have happened is, because I understand plaintiff's argument is that the claimant was in the hospital for a period of time and could not go to the police station to make a report or contact authorities to do the same. But they at least could have tried to do so within a reasonable time after the fact, and then argued to Member Select, well, I couldn't do it under the confines of the policy limitations, but here's why. That was never done. That was never attempted. So we're stuck with the record. And I think based on this record, it's insufficient to meet the policy conditions for benefits.
Does let's assume that the fire department report, instead of saying Detroit Fire Department on the top, said Detroit Police Department. Would that report be sufficient for Member Select's policy?
Well, I think that begs the question. I know we're going into like that.
It's a simple question.
Well, I think it depends, Judge. I think it would depend if the report were generated upon the claimant making.
No, I know there's lots of different facts. I presented one, right, which is just, it says Detroit Police Department instead of Detroit Fire Department at the top. Everything else is the same.
I think it's clearly closer in that scenario, where it's that you actually have a report coming from a law enforcement agency as opposed to a fire department, which my understanding of the was the Commission on Law Enforcement Standards Act, which has certain definitions of law enforcement officers, that a fire arson investigator is considered a law enforcement officer. I don't know of other fire department firefighters or other fire department personnel that would fit within that definition. So, but in your situation, Judge, I do think it's a lot closer. If that report did come from, say, Detroit Police Department.
But under your situation, I guess, even if it said Detroit Fire Department and it was authored by a fire arson investigator who is a law enforcement officer, it still wouldn't be, the report wouldn't be from a law enforcement agency. So it arguably wouldn't suffice, right? So, I mean, I'm not sure where that gets us, but I just was curious as to your answer. Thank you.
I hope I answered it as
you did
as best I could. Absent any further questions, I'll rest on our briefs. Of course, we ask the court affirm.
Thank you.
Thanks.
Very quickly, all I would point to is, again, I don't see any prejudice. I think there was substantial compliance and there wasn't any prejudice. So with unless you have questions.
I have one question.
Yeah.
I don't know who's this best. When I looked at the record, was count one ever formally dismissed?
Count one being the bodily injury claim.
It was the third party claim against the purported driver of the vehicle.
Yeah, as far as I know, there was a default entered at some point in time, I believe, or not a default, but no, it was not ever fully dismissed. But then there was, I believe, a final order entered at some point that theoretically would cover that.
Okay.
But I don't know off the top of my head. Apologies. Any other
I
questions?
don't know if you have, if, I know your time's up.
No, feel free.
It's just, I don't know that it matters, but it was something that I missed in the record, so.
All I can say, Judge, is it's not specifically referenced in the final order.
Okay.
Any other questions?
Any other questions?
Right.
No.
Thank you. The matter has now been submitted. We will now return to. Yeah.
Vito,
What about 11?
about 11.
So if someone hasn't checked in, then. Yeah, I'm gonna go chronologically as best I can.
I am. I'm trying to communicate with Lansing and the courtroom at the same time.
Again, we didn't hear it.
Sounded like she said she's trying to communicate with the courtroom and Lansing at the same
Hello,
time.
Judge Ackerman, can you hear me?
Yes.
Hi, this is Tara. I'm in the background trying to bring in Mr. Shutza. It seems that he's having some trouble joining, so I'm going to keep working with him to bring him in.
Okay. So then let me, while we have you, is Mr. Deal available in case number 10?
He is. Would you like me to bring him in?
We'll try to stay in order as best we can. So I will now call item number 10, case number.
She's in the other courtroom.
I think that's case number 9. Number 9 is where counsel's in the other court.
Thank you.
So now call item number 10, case number 377-938, in Ray Turner Minor. Yes, for Mr. Deal. She just said he's available and.
Good morning, Your Honors, or afternoon, rather. Good afternoon, Your Honors.
Whenever you're ready, Mr. Deal.
Oh, thank you very much. So my name is Ryan Deal, P number 60599, appearing on behalf of the respondent father in this matter. Honestly, Your Honors, I have fully briefed this matter for the court, and I'm here to answer or address any questions that the court may have. Otherwise, I rely on the brief that I submitted.
Any questions?
No.
Well, thank you. It was well briefed. We appreciate it. That matter has now been submitted. We'll move
Thank you
on.
very much, Your Honors. Have a wonderful day.
You too. We will now call item number 11, case number 379-315, Inree Wheeler Miners. Then no one checked in. We will, that matter is now submitted. We will move to item number, unless I hear otherwise, it will keep going in order. Item number 12, case number 379-442, Henry Club Betts Miners. Okay. Let me check, did we? Yeah, you were on number 9 too. Well, is opposing counsel here for number 9? No, it's just you. Okay, well, we just called number 12. If we could jump to that, if you need a second to prepare between that and the other case, that is very understandable.
Nope, I am ready, Your Honors. Again, I appreciate the court's courtesies. I'm sort of playing hot potato today, as mentioned previously. For the record, Your Honors, Ashley Stone on behalf of the St. Clair County Prosecutor's Office for the People. I believe this case that we just called regarding respondent mother Lydia Ann Betts. I will largely rely on my briefing. I'm happy to answer any questions the court might have. I know in this case that the respondent mother had serious substance abuse and mental health issues that sort of been well documented throughout the pendency of the case. At the time, she admitted to the petition and the allegations in the petition when the court took temporary jurisdiction. And based on what was in that petition, I think there's clearly a preponderance of the evidence for that temporary jurisdiction. Really, I understand defendant's argument to just be that the petition didn't contain enough information because it was a no contest plea. And I would disagree. I think that it's well documented, the issues, including that she admitted to methamphetamine use while pregnant with one of the minor children, that she did not know where two of the other minor children were placed or who they were with, and that there were some significant other issues, I think just involved, again, with her substance abuse and mental health issues that translate into really unsafe decision-making for these kids. I think that the petition contained plenty of information for statutory grounds to be found, and I'll leave it with that if the court has any questions.
Any questions? Thank you very much. That matter has been submitted. I guess I was trying to look at that. I'm going to call it, and then item number 13, case number 374-778, Guba v. Elta Harry. With no one before us, that matter has now been submitted. I guess we'll complete 14 and then return unless the Zoom has been resolved. Trying to bounce around this is my apologies to everyone. This is the technological challenges are all right. Well, let's number 9 while we have Miss Stone, who's running around everywhere today. Item number 9, case number 379-439, in re Dupuis minors. I may have.
As far as I know, that's correct, Your Honor. Ashley Stone on behalf of the St. Clair County Prosecutor's Office for the People. Similar to the other termination case that I'm here on today, this is one where the respondent father ultimately pled no contest and admitted to all of the allegations outlined in the petition. Those included allegations that ultimately underlined a charge for child abuse in the 2nd degree. It outlined violent behavior, including that he was seen beating and choking minor MD in the school parking lot after she had made some disclosures about respondent mother's abuse of her. And he also made comments that really evidence a dangerous state of mind in his efforts regarding the other minor child, CD. And so all of those things were outlined in the petition, which he admitted to or pled no contest to. And therefore, I think a preponderance of evidence existed to take temporary jurisdiction. Again, I don't see a specific attack or disavowalment of the allegations of the petition from defense, just sort of a general allegation that the petition did not contain sufficient allegations, and we just frankly disagree. Are there any questions that I could answer for this court?
Any questions?
None.
Thank you.
Thank you, Your Honors. I
Matter
appreciate
has
your patience with me today.
now been submitted. I'll ask, I guess, 1 second to last time for if the Zoom has been corrected.
Hi, Judge Ackerman, this is Tara. I can see him in the courtroom, in the gallery, but I can't seem to, he doesn't seem to have video, and he seems to be having some microphone issues on his computer at home.
All right, I'll call the last case, and if that's not resolved, we grant our argument, but I think there's an expectation that you have the technology and the setup to to participate, and that's not incumbent on us. So we'll call now. My apologies to, to council. So item number 14, case number 375-093, SRM v. Michael for v. Lester. And believe we have limited oral argument for both sides based on the motions and failure to reserve oral argument in the briefs. And I guess while we have that, yeah, please proceed.
Good afternoon, John Knockisel on behalf of plaintiff appellant again. I'm going to be very, very quick on this one. The first point I'm going to make is this is not an abusive discretion standard. Defense claims that in their brief. It's a de novo standard because it's the review of the argument itself. It's not the application of the settlement. It's not whether or not to apply the settlement agreement. It's whether or not there existed a binding contract, a binding settlement agreement in the first place. So the correct standard of review is de novo, not abusive discretion. Then the only other point I want to make, and then I will reserve the rest of my time for rebuttal, is that there was this agreement that defendant would pay approximately $200,000 in exchange to resolve the case, dismiss it with prejudice, and that plaintiff would take on the burden of dealing with Medicare and getting that lien resolved. They then, for reasons unknown, just decided, oh no, we're just going to pay the Medicare lien and try to back out of the settlement agreement that the parties had already agreed to. I think there was a meeting of the minds as to the deal, and they then recanted, and they're not allowed to do that because it was a binding agreement. Any questions? Okay, I will save my time for rebuttal.
Thank you.
Good afternoon, Your Honors. Maureen DeMarco on behalf of defendant Appellee Allstate Insurance Company. I respectfully disagree with brother counsel about the standard of review applicable to this case. But regardless of that, I think upon a review of the entirety of the record, it shows that the trial court made the right call here. By plaintiff's counsel's own designation at the onset of these settlement negotiations, he labeled this settlement agreement as contingent and tentative. March 10th of 2023, he sends the first email regarding this tentative settlement and labels it as such. He mentions that it must be contingent because of a massive Medicare lien and that he plans to file a motion to approve any potential settlement pursuant to MCL 531-12. He then signs off the email saying, I will let you know if/when I get Medicare approval. In no way was that a confirmation of some final binding settlement between the parties. Approximately a month later, counsel for Allstate sends a proposed release to plaintiff's counsel. Before any changes were even proposed on that release, plaintiff's counsel sent an email to the court. The court was inquiring about the status of the upcoming trial, settlement negotiations. Plaintiff's counsel emails the court saying, the parties are working on a settlement, but refers to Medicare as the hang-up to any potential settlement. Again, describes the lien as very large. We'll need a motion to approve that settlement, and informs the court that Medicare is moving slow. He also shared an email from a third-party company that they were allegedly using to attempt to negotiate this massive Medicare lien. And I think it's important to point out that this lien is in excess of $250,000, which is more than Allstate could ever become obligated to pay this plaintiff in PIP benefits statutorily. The claim was assigned to them by the Michigan Assigned Claims Plan. So it was very well known that this major issue needed to be resolved before any type of settlement could be reached between the parties. At that point, there was in no way a final binding settlement of any kind. On June 1st of 2023, plaintiff's counsel finally responds to the proposed release that was sent to them in April with changes due to concerns with the Medicare lien that they were still allegedly negotiating. We made those changes and sent them back to plaintiff's counsel. Then a few weeks later, at the end of the month, plaintiff's counsel requests additional changes, specifically to add language that any potential settlement needed to be approved by the court again, because of this issue with this massive Medicare lien that he still is working on.
Counsel, I don't want to interrupt you, but we are aware of all the facts and you've thoroughly put this in your briefing. I mean, ultimately, the revocation is before the issue with Medicare is resolved. Is that correct?
Yes. So that is the point I am trying to make after reviewing this entire record, where plaintiff's counsel completely affirmatively indicates over and over and over again that their own settlement is contingent. The trial court made the right call based on that information. None of the conditions that needed to be fulfilled before a settlement could be reached were done before July 25th of 2023, when Allstate was forced to revoke the offer because of the lien that was asserted by Medicare. It was threat of, federal debt collection, including garnishments against Allstate. They became obligated to pay the lien. They paid every dime of coverage that was left under the statute, revoked the settlement offer, and there's nothing left to be paid out to the plaintiff in this case. So we believe that the trial court made the right decision, and we're asking this court to affirm as well.
Any questions? No. Thank you.
Thank you.
Mostly, I'm just happy to answer any questions you have. The only point I would reiterate is that before the point where the settlement agreement was rescinded, the parties had agreed to language saying that plaintiff would be responsible for dealing with Medicare lien, which was the sole issue of contingency or issue that hadn't been settled prior to that. There was a meeting of the minds on that issue and on the settlement amount. I don't know how then Medicare sending a letter changes that when the parties had agreed on paper. All they had to do was issue the final release. They had already agreed to the actual terms that were at issue.
Okay. Thank you. Thank you both. The matter's not been submitted. We will now call the final case of the day, and hopefully the Zoom is fixed, but
So if it's not ready, I don't know if the court would be willing to even wait just 5 minutes. She can return. If not, I completely understand, but
well, I guess first, I mean, I can't imagine it wasn't fixed for that long, and now it's fixed 2 minutes later. From Lansing.
There's a panelist.
It looks like he's having some trouble, Judge. I'm sorry. I'm doing everything I can. We've sent him the link several times
Well,
to try to get him in the courtroom, and it doesn't seem to be working on his end.
If neither side is ready and she wants a brief, why don't we take a 5 or 10 minute brief recess, and then we'll come back. We appreciate you.
no, I appreciate
your
the support
patience.
very much. Thank you.
All right, ready or not, we're gonna call item number 7, case number 374-581, Smith's Designer Construction v. Ellis.
Hello, Judge Ackerman. This is Tara. Mike just sent the attorney the link to, or the phone number to dial in. So he'll be available by audio, but we will not have video for him.
Okay, that's the best we can do, yeah. Okay. Might make a note in case he requests remote oral argument again in the near future.
I'm on audio. This is John Schutzer.
All right, whenever you're
Hello?
ready.
Thank you. Beth Whitman appearing on behalf of the defendant and also the third-party plaintiffs in this case, the Ellises. And as I indicated earlier, Ms. Ellis is here in the courtroom today. So in this case, the trial court obviously set aside a default judgment against Strictly Heating and Cooling. Or it wasn't a default judgment, I'm sorry. It was a default entry that was properly entered by the clerk of the court. There is no question that the complaint was actually served on Strictly. The trial court here recognized they had an argument with respect to good cause, meritorious defense. The trial court held that there was good cause, did not, however, make any finding whatsoever with respect to a meritorious defense. So for that reason alone, I think this case has to go back to the trial court to make some sort of determination with respect to a meritorious defense. But it's also problematic, the trial court's ruling with respect to good cause as well. The trial court held that the good cause had been established because Strictly had not been served with a copy of the default notice or the default judgment. There's testimony, or I'm sorry, not testimony, but there's evidence in the record that the third-party plaintiffs' counsel did serve. She certified that she had served a notice, the default notice on the attorney, and also that she had she indicated at the motion hearing as well that she had served it on the attorney for Strictly. I'm sorry, on Strictly, not the attorney for Strictly, because I don't think the attorney for Strictly actually appeared until I think the day before the hearing on the motion for for default judgment. So, but the really difficult part here is that the trial court issued this ruling on, finding that there was this good cause without giving the Ellises an opportunity to file a response to the motion to set aside the default. So the Strictly had filed that motion the day before the hearing. The Ellises weren't entitled or didn't have an opportunity to respond to that, didn't have an opportunity to try to argue against the good cause argument or say that they were in fact served or show any proof of that. They did have, of course, the default entry that showed or certified that it was in fact served. But anything else that the attorney had indicated that they weren't served, the Ellises weren't entitled or offered that opportunity to prove that they were in fact served. It's interesting too. There was a finding by the trial court that there was a reasonable excuse for for failing to respond to the complaint, that third-party complaint. And the difficulty with that, they said they were told by Mr. Smith that they didn't have to do anything. He was going to handle it, not to worry. But the third-party complaint had allegations in it that specifically said that Smith had sent a notice of non-party fault indicating that if anybody had messed up on the HVAC system, it was Strictly. So given that completely contradictory statement that they had, there's no dispute whatsoever that they were served with a copy of the complaint, that third-party complaint. So they knew, in fact, that Smith was not actually saying that everything was okay.
Wasn't that ultimately a credibility determination that was made by the trial?
I think so too. I mean, it is hearsay as to what Mr. Smith allegedly told them, but it was in an affidavit where he says that. But yes, I agree with you. So it's problematic, I think, all around for the trial court under these circumstances where there was not an opportunity to respond to the motion to set aside the default, and to make these determinations that there was not service and make the determination that there was a reasonable excuse under these circumstances. I have the second issue with respect to the summary disposition motion. The court doesn't even need to reach that if, in fact, the court agrees with me on the first issue with respect to the default. I would be happy to rely on my brief on the issue with respect to summary disposition unless the court has any questions on that.
I do, sort of.
Okay.
I guess I'm having a little bit of trouble with how the trial court addressed the summary disposition motion.
Mhm. Me too.
Specifically, the fact that there was also a claim for unjust enrichment that was not addressed at all.
Not at all.
And depending on the interpretation of the trial court's order, it's not, I don't want to characterize it, but it's not clear that your clients were given an opportunity to file an amended complaint, which would normally be, if you're going to, do a failure to state a claim sort of analysis. But then I get to, well, so what? And this doesn't really get to that issue, but ultimately there was a trial.
That is correct. Yeah.
Right. And ultimately the plaintiff prevailed over your client, the defendant.
In that underlying case. Yes.
But the issue of the work on the HVAC unit would have been litigated in that, right, as the general contractor, right? So assume, I have some thoughts on whether your clients were the third-party beneficiaries of the plaintiff's contract with Strictly.
Correct.
Okay,
Yes.
but let's just assume you are, and your clients could plead a breach of contract claim. Presumably, in order to support that, you would have also had to litigate against Smith's Designer kind of what happened with respect to the HVAC unit, because they were the general contractor.
Mhm.
And given the result of that trial, does the result of that trial say anything about your client's ability to prevail, even if we were to remand the case?
I don't think so. I mean, this obviously hasn't been.
And why?
And I would be happy to submit a supplemental brief on that issue. I mean, again, we're dealing with a defendant that hasn't even appeared in this case, didn't file any brief on appeal, and contradictory, Strictly never filed a brief in this case. Smith did, but Strictly did not. So Strictly hasn't raised that issue that it's, barred because of res judicata or anything else.
That's my question.
Yeah, so I'd be happy to submit a supplemental brief to this court in addressing that issue if given the opportunity. I would certainly be happy to do that.
I guess I'm understanding the question to be more of, it was litigated. It have not been litigated by Strictly, but it was ultimately litigated by Smith in the trial. And so what would be different if Strictly, I mean, I'm assuming you had or your client had the same incentive to really go after the HVAC system and the workmanship on that as part of their case against Smith. And so how does that?
And I that's what I'm saying. I don't know the answer to that. I can't tell you that off the top of my head. This is, something that was not addressed by anybody at any point on the appeal. And I appreciate the question. I'd be happy to address it, but I need to do that in a supplemental brief or something, because the question is whether or not essentially that would be res judicata as to my client.
All right, let me ask the question in a different way. Did your client in the trial have a reason to attack the workmanship of the HVAC system to the best of their ability?
I don't
during
know.
the trial?
That's the best answer I can give you. I don't know. I don't know the answer to that.
But wasn't that part of the allegation that it was poor workmanship that led to the issues?
But I don't recall at this point if that was specifically litigated, the HVAC system was specifically
I see what you're
litigated. I just don't recall. This is, I apologize. I just don't know the answer to that.
And I know it may have been an unfair question, given that it wasn't brief, but it's sort of the next step of, you're asking for relief of remand, but for what purpose is kind of but I understand your answer, and I appreciate it.
Okay, and that may be something that Strictly, if they can get out from underneath the default, they'd have to get the default set aside, because I think that's the most important thing. The default stands. They can't litigate against that default. They can't make this argument that there's somehow res judicata or something like that would apply, because they're in default.
But they could argue no damages.
They could try to argue no damages. They could attempt to argue, I suppose, like that ruling with respect to what the trial court did in the underlying action has some sort of preclusive effect as to the claim, the third party claim that my client has against Strictly. But I at this point, nobody has made that argument, number one, and I think they're foreclosed from doing that if they are in default. That's the important thing. Because as this court knows, I mean, obviously this wasn't briefed either, but I think it's pretty standard knowledge that you can't argue that you're not liable when you're in default. The default makes it so that you can no longer argue that you don't have liability in the case. You can argue damages, but you can't argue liability. So to the extent that this crosses over into we have no liability, then they can't argue that. If they want to try to say, well, you don't have any damages, I don't know. I mean, that's going to be an interesting question, but one that I think the trial court, or I'm sorry, Strictly would have to make in the trial court, assuming this court reverses, obviously, the setting aside.
Any questions?
Nothing more.
You've time for rebuttal.
Okay, wonderful. Thank you.
Mr. Schutza?
Good afternoon. I apologize first and foremost to the court and counsel for the delay encountered by unexpected technical problems. I will be very short. I rely on my brief. I filed a brief out of an abundance of caution.
I'm sorry. This is not your fault. There's like a fire siren, it's a police siren, so it's a little hard for us to hear. Could you just wait 1 second? Yeah, and 1 second. It's the siren's still going. It's just hard to this is not your fault. Even if you were on video, it wouldn't matter.
One of those days.
Can you hear it?
I can hear you just fine.
The sirens. Sorry. Now it's finally dying. Would you mind putting your appearance on the record and starting over? My apologies. It was just some like police cars outside of the courtroom.
John Schutza, appearing on behalf of Smith's Designer and Construction. I said initially I'd like to apologize to the court and counsel for the delay encountered because of unexpected technical problems at this end. I filed a brief out of an abundance of caution, but all I'm asking the court to do is to affirm the favorable result obtained on behalf of my client in the trial court. Plaintiff or the Ellises rather, have not made a single claim on appeal of any error as to my client, and to the extent they were going to do that, that's been abandoned. So there's nothing in the statement of questions about my client. There's nothing in the brief about my client. So I'd ask the court to affirm the result as to my client.
Any questions from the panel?
None.
None. Okay. Well, thank you very much. I appreciate your patience with the police cars.
Thank you very much. Bye.
Rebuttal. Any further questions?
No.
Well, that concludes, the matter has been submitted, and I think that concludes case call session for the day.
Thank you very much.
Thank you. Thank you
Kudos
for
to
your
Judge
patience.
Ackerman for keeping track of all the numbers.